It's a writ of certiorari. That's what it's called, right? Hold on, let me
This
watch
is
through.
60 Second Civics from the Center for Civic Education. I'm Mark Gage. The litigant or party involved in a lawsuit who loses in a federal court or the highest court of a state can ask the Supreme Court to review the case. The party does so by filing a petition for writ of certiorari. The Supreme Court is not required to issue a writ. The court's rules currently state that the justices are more likely to allow review if there is disagreement among the federal courts of appeal on a legal matter. If 4 Supreme Court justices vote to allow review of a case, then the court issues the writ, which commands the lower court to send the record of the case to the Supreme Court. The court traditionally does not explain its rationale for accepting or rejecting cases for review. Each year, the Supreme Court receives thousands of petitions asking it to issue a writ of certiorari. The justices accept only a small fraction. The number of cases that the court decides has...
The primary means to petition the court for review is to ask it to grant a writ of certiorari. This is a request that the Supreme Court order a lower court to send up the record of the case for review. The court is usually not any application. Okay. Certiorari to the United States Court of Appeals for the District of Columbia Circuit. So that just means that the Supreme Court is responding to the request for review coming up through the circuit, the D.C. Circuit. Okay. Which circuit is that? Does it have a name, or is it just called the D.C. Circuit? Is this like the 12th, the 3rd, the 4th, the 8th, the 50th? I think we only have 9 or 10 circuits, right? We call it the D.C. Circuit. Is it just called the D.C. Circuit? Oh, there's 13. Okay. This was argued on the 25th of 2024, decided on July 1st, 2024, today. A federal grand jury, wait, music. My piano music, okay. A federal grand jury indicted former President Donald J. Trump on 4 counts for conduct that occurred during his presidency following the November 2020 election. The indictment alleged that after losing that election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the election results. Trump moved to dismiss the indictment based on presidential immunity, arguing that a president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibilities, and that the indictment's allegations fell within the core of his official duties. The district court denied Trump's motion to dismiss, holding that former presidents do not possess federal criminal immunity for any acts. The D.C. Circuit affirmed. Both the district court and the D.C. Circuit declined to decide whether the indicted conduct involved official acts. So the case here that President Trump would be arguing to dismiss, I believe, when we're talking about the indictment alleging that after losing the election, Trump conspired to overturn it by this would be the Jack Smith federal indictment, the Jack Smith federal case. Now, whether this would carry over to the state Georgia RICO case that has many of the same allegations in the indictment, I don't know if it would or wouldn't. Not sure, but okay. Held. Under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecutions for actions within his conclusive and preclusive constitutional authority, and he is entitled to at least presumptive immunity from prosecution for all of his official acts. There is no immunity for unofficial acts. Probably pretty important. Let's check real quick if there's a legal definition for presumptive immunity. Hey, buddy, do you want to check out Factorio Pina? Okay, people that just like suggest like the most random, unrelated fucking things. They are not even remotely related. We'll say 30-day ban. This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. Determining whether and under what circumstances such a prosecution may proceed requires careful assessment of the scope of presidential power under the Constitution. The nature of that power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. At least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. As for his remaining official actions, he is entitled to at least presumptive immunity. I think I would tentatively agree with that argument. There's probably some things that we don't want, maybe, for the president to have coming under criminal review, possibly, maybe. I'm like open to that, but I haven't thought hard about both ends of that. I've served on active duty for 19 years. I'm pressing the button at 20. I can't imagine getting orders that my commander wouldn't be on the hook for. I don't recognize the USA anymore. Fuck monarchy. Jesus. Wait, let me check real quick. Presumptive immunity for measles. Why did I Google this? Presumptive immunity. And it's all news things. Presumptive immunity before 2023. Presumptive evidence of immunity can be established in any of the following ways. Measles. Wait. Presumptive immunity. Law. Legal. Does this fall under like they just invented it. Oh, is this like not a real thing? I know qualified immunity is a thing. Okay, presumptive immunity before 2023. Huh. Interesting. Do I take notes on these? Sure. New note. At least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. As for his remaining official actions, he is entitled to at least presumptive immunity. Are there a such thing as core? When they say core constitutional powers, do they just mean things explicitly in the original Constitution? Core powers president. Is this a term that's ever explicitly spelled out? Before 2023. Notes. We'll just put questions. No, not questions. What are core powers of the president? Let's write these down. We'll keep in mind as we go. What is the difference between absolute versus qualified immunity? I should know this. Okay. Can you move this over so we can see? Let's see. I would need to create a new layout. Launch layout editor. Create new layout. We'll call this iPad layout. Right here, save. Okay. Article 2 of the Constitution vests executive power in a President of the United States of America. The President has duties of unrivaled gravity and breadth. Referencing Trump v. Vance. His authority to act necessarily stems either from an act of Congress or from the Constitution itself. Referencing Youngstown Sheet and Tube Company versus Sawyer. Hold on. Is this too loud? Man, it's fucking annoying. In the latter case, the president's authority is sometimes conclusive and preclusive. When the president exercises such authority, Congress cannot act on and courts cannot examine the president's actions. That's important to understand. So Youngstown Sheet and Tube v. Sawyer. Court case grants the president some actions that are not reviewable. We should see what that case actually says. When the president exercises such authority, Congress cannot act on it, and courts cannot examine the president's actions. So to be clear, when somebody says the court can't examine it, what that means is that there is no criminal review, meaning if you do it, you can't even ask the question legally of, was that allowed? Was it not allowed? I don't know. The court's not allowed to even look at that particular thing. Let's see. It follows that an act of Congress, either a specific one targeted at the president or a generally applicable one, may not criminalize the president's actions within his exclusive constitutional power. Neither may the courts adjudicate a criminal prosecution that examines such presidential actions. The court thus concludes that the president is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority. Not all of the president's official acts fall within his conclusive and preclusive authority. The reasons that justify the president's absolute immunity from criminal prosecution for acts within the scope of his exclusive constitutional authority do not extend to conduct in areas where his authority is shared with Congress. To determine the president's immunity in this context, the court looks primarily to the framers' design of the presidency within the separation of powers, precedent on presidential immunity in the civil context, and criminal cases where a president resisted prosecutorial demands for documents. The framers designed the presidency to provide for a vigorous and energetic executive. The Federalist number 70, pages 471 472, by some guy named Asshole Hamilton, they vested the president with supervisory and policy responsibilities of utmost discretion and sensitivity. Nixon v. Fitzgerald. Fuck. Okay. One of the things that Vivance poisoned my brain on is that when I would go and I would read underlying citations, the citations were not accurate. I distinctly remember in oral arguments before the Supreme Court, Donald Trump's judge brought up something to do with not wanting to have to criminally indict a sitting president. It was a quote by Benjamin Franklin. and why impeachment should be used instead or something. This quote was used in the oral argument to further the idea that a president shouldn't be criminally liable for things. But if you actually go up and you read the context where Benjamin Franklin uttered that statement, what he was saying was impeachment is important to be able to remove a sitting president because we don't want to have to fabricate criminal charges or murder the person in office to get them to step down. That's why impeachment was important. Nothing about that conversation implies that Benjamin Franklin was saying that a president should be above criminal prosecution. He was just saying it was important to have the process of impeachment so we don't have to kill or fake criminal charges to remove somebody from office. So when the Supreme Court cites these court cases, I just want to go and read the underlying case, but I don't have time to read every single court case. Or maybe we will. Who knows? Okay. Appreciating the unique risks that arise when the president's energies are diverted by proceedings that might render him unduly cautious in the discharge of his official duties, the court has recognized presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by our history. I think we should. I'll write this here. Nixon v. Fitzgerald. What kind of presidential immunities and privileges was the court talking about in this case? In Fitzgerald, for instance, the court concluded that a former president is entitled to absolute immunity from damages liability for acts within the outer perimeter of his official responsibility. The court's dominant concern was to avoid diversion of the president's attention during the decision-making process caused by needless worry as to the possibility of damages actions stemming from any particular official decision. Just real quick, when we're reading stuff, when you say id, it just means it's referring to the former thing that was already cited, right, basically? It is citing the former source. Yeah, okay, yeah. When somebody says chat on screen frozen, I don't know why the chat is freezing so much. If it does it again, we're throwing back up kick chat. I don't know why the on screen chat keeps freezing. Oh, I can't even refresh it in OBS. Also, when we say Nixon v. Fitzgerald, 457 U.S. 731 750, is 457 like the case number, or what are we referring to here? So 457 U.S. 731, 750. Nixon v. Fitzgerald, 457 U.S. 731. What does the 750 mean? Were there two different cases? Nixon, okay. 57 U.S. 731. 7 U.S. The book volume is 457. Page start number is 731. Goes to page 750 and ends there. Oh. What is the book? Is that like an official book of Supreme Court rulings? Is that what it's published in? U.S. Okay. Are these books that it's referring to, 457 U.S., are these only books for the Supreme Court, or are these books for the entire U.S. judicial system, or are these books for the entire, government stuff?
Hey.
Hello?
I can barely hear you.
Oh, okay.
Oh, no, I can hear you now. Just to give you a quick overview, when you're talking about, 457 U.S. 731, these are pin sites. These are supposed to be very easy to find references to the case or the specific point in the case that they're trying to reference.
Okay.
So 457 is the reporter volume, I think, and then U.S. will tell you which court. So you'll have like D.C. Circuit. So it'll be like 457 D.C. Circuit might be the case before this in the D.C. Circuit. And then your 731, 750 are your specific page citations within that reporter. So
Okay, gotcha. I understand. Okay, cool.
Yeah.
So when it says 457 U.S. 731 and 750, these are the two pages that they're referring to. And then
Yes,
when they say
correct.
id 749, 751, 752, they're referring
Same
to
case.
those pages.
Yeah.
What
The
does
same source,
N32
just-
mean? Number 32.
Well,
Maybe a figure
So
or
if
something
you're
on the
saying-
page, or
N32 might be notation or footnote 32.
maybe. Okay, cool. Got it. All right.
All right.
Cool. Bye. Okay. In Fitzgerald, for instance, the court concluded that a former president is entitled to absolute immunity from damages, liability for acts within the outer perimeter of his official responsibility. The court's dominant concern was to okay. So I haven't read these cases, so I'm just going by the little bit of legal stuff I understand. So if I'm wrong, either somebody can correct me or whatever. We can probably agree that civil damage immunity is probably important, for public officials when they're acting in service of public officials, because you don't want somebody to be able to sue the government for doing things that might cause civil damages. For instance, if the president orders a lockdown or whatever for a virus, or orders a curfew, and you lose out on business or something, right? You wouldn't be able to sue the president of the United States for civil damages for your business because these are functions of the government. It would be impossible for the government to function if like private causes of action happened every single time, or if there were private like litigation happening every single time something happens, right? So civil protection is probably vitally important, even absolute civil protection is probably really important. However, civil stuff and criminal stuff, remember, okay, if there's anything you take from the stream and all the legal bullshit we do, it is in your mind. Civil, criminal. These are two completely distinct and separate things, okay? But anybody that challenges me on this is getting IP banned permanently for a while, actually, including lawyers in chat, okay? Civil and criminal are two different things. Civil generally involves a plaintiff and a defendant or a plaintiff that is a plaintiff, meaning a person bringing a case, who's just a private citizen who feels like they've been wronged in some way, where they're suffering damages, where the remedy is usually some type of like financial compensation, okay? Criminal charges are you've broken a law, okay? And now a court, meaning that an attorney who's representing either can an attorney represent a city, a state, or a government, some kind of government is bringing a charge against you, and the prosecution of that and then the conviction on that will oftentimes lead to a loss of liberties, meaning you might be imprisoned, you might be like legally compelled to pay fines, you might lose other rights depending upon whatever. But criminal charges are when governments are bringing charges against individuals for breaking the law. Civil charges, or you wouldn't even say civil charges generally, civil cases are when individuals are bringing charges against others because they feel like they've been damaged in some way. That's not criminal. Now, for the actually, that some fucking losers in chat, especially lawyers, might want to point out, there can be civil things that have a tie-in to criminal things, but it's still not the same thing, and it's not relevant here. For instance, Donald Trump's rape case was not a criminal case. It was a civil case. I didn't follow that case directly, but I think somebody was trying to sue him for damages or whatever based on, because they felt like they were raped or sexually assaulted. That wasn't a criminal case. That was a civil case. After civil cases, generally you're remedying an injury from the plaintiff, meaning you're paying them, you're doing something for reconstitution to make whatever thing right. However, there's not like a deprivation of liberty there. You're not going to be imprisoned as the result of a civil case, or something like that. There was one more thing. And another important thing is that a civil case, in order to win a civil case, the legal expression used is a preponderance of evidence, or in some countries it might be a balance of probabilities. Basically, you have to prove that it was more likely than not that the person did the thing. So commonly, I think we refer to this as like 51%. More likely than not that the person did this thing that the plaintiff is alleging them of doing. Plaintiff being the person who brings the case, defendant being the person defending against the case. In criminal court, for a criminal conviction, meaning either a judge or a jury has decided that you've been convicted of the crime, the charges brought against you are accurate, and they're going to convict you of that crime. and that crime conviction is breaking a law and it could lead to the deprivation of liberty, you need something called beyond a reasonable doubt, which I've heard expressed anywhere from 95 to 99%. Like, no reasonable person could have a reasonable doubt in their mind that the person committed this particular action. So the threshold for a criminal conviction is much, 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 much higher than the threshold to win a civil case, okay? Okay, just random bullshit stuff. Okay. By contrast, and then also I saw Pisco type something in chat. Okay, calm myself. Man, I hate conservatives. Hatred. When conservative Supreme Court justices argue for making huge decisions in the interpretation of our law in the United States, you'll hear these words that come out over and over again, called history and tradition, rooted in our legal tradition, rooted in our legal history. So far, this might be me speaking in an uneducated manner, maybe whatever, but so far, I will note that it seems like a lot of the cases that are being referenced in here are quite new. Within the past 100 years, these are not historical common law from the UK, or I don't even know, from England or whatever. These aren't cases from the 1600s, the 1700s. Most of what's been referenced here is fairly recent. Just as a heads up, just something to keep in mind, okay? Because I am not a legal scholar, but sometimes it feels like the conservative Supreme Court justices like to float around sometimes when they talk about that history of tradition and what's rooted in our legal history and whatever. Like just saying sometimes they play around. They play around with that sometimes. Leo be damned. Just as a quick thing before I perma-ban you, you said, destiny knows better than an actual Supreme Court judge, literal definition of uneducated. So this Supreme Court decision came down on a 6-3 party line. There are 3 Supreme Court justices that agree with me. I don't know who the fuck you are, but I do know that you're perma-banned from chat. See ya. Okay. By contrast, history and tradition analysis is only for finding unenumerated rights as far as I know, not for all constitutional analysis. Okay, Shilling Spree. Again, my constitutional history is bullshit. I don't know anything. But so then I'm sure I must have missed the part in the Constitution that says the president shall not be held criminally liable for any action taken while president. That must be explicitly spelled out somewhere. I'm just not aware of it. Maybe it's in an amendment. Maybe I missed, I don't know, fucking half the amendments. I don't know, 90% of the amendments. So maybe it's in an amendment that I'm not aware of, and they'll point that out here. I don't know why they wasted 120 pages on this. I'm sure it's strictly enumerated somewhere. So we'll find it. Okay. By contrast, when prosecutors have sought evidence from the president, the court has consistently rejected presidential claims of absolute immunity. During the treason trial of former Vice President Aaron Burr, for instance, Chief Justice Marshall rejected President Thomas Jefferson's claim that the president could not be subjected to a subpoena. Marshall simultaneously recognized, however, the existence of a privilege to withhold certain official papers. United States v. Burr. 25F. Okay, so I see case. So we've got the reporter, volume 187, page 192. What do you think 25F CAS means? Tell me that. It's the court. Oh, you're right. That is the court part. 25F.cas. Maybe they used a different labeling because our whole system could have been different back then. Oh, F stands for federal. CAS stands for case, maybe? CAS is just the report/court label. Okay. Okay. And when a subpoena issued to President Richard Nixon, the court rejected his claim of absolute privilege in the United States v. Nixon, but recognizing the public interest in candid, objective, and even blunt or harsh opinions in presidential decision-making, it held that a presumptive privilege protects presidential communications. That might give us an answer for as to what we're saying this presumptive privilege might be. Okay. In United States v. Nixon, 418 U.S. 683 and 703, those two pages, we would say, what is presumptive privilege relating to presidential communications? Question mark. Because that privilege relates to the effective discharge of a president's powers, the court deemed it fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. And 711. Criminally prosecuting a president for official conduct undoubtedly poses a far greater threat of intrusion on the authority and functions of the executive branch than simply seeking evidence in his possession. I don't want to sit here and second guess every statement. Do I agree with that? Criminally prosecuting a president for official conduct undoubtedly poses a far greater threat of intrusion on the authority and functions of the executive branch than simply seeking evidence in his possession. Is that true? I can think logically this argument fails because if the threshold for criminal prosecution is much higher than the threshold for simply a subpoena, you could argue that allowing them to be subpoenaed is a greater threat than criminal prosecution because the threshold for subpoena is so low you could subpoena everything. I feel like just on a logic point of view, I feel like that argument fails. But on a greater point, it may be arguable, I guess, prosecuting the president for whatever. That's not that important. The danger is greater than what led the court to recognize absolute presidential immunity from civil damages liability, that the president would be chilled from taking the bold and unhesitating action required of an independent executive. Citing Fitzgerald, although the president might be exposed to fewer criminal prosecutions than civil damages suits, the threat of trial, judgment, and imprisonment is a far greater deterrent and plainly more likely to distort presidential decision-making than the potential payment of civil damages. I don't think I agree with this. If I was working a certain job and somebody told me you have two choices, you can either people can sue you for either one thing. Do you want immunity from criminal charges or do you want immunity from civil charges? I think I would ask for immunity from civil charges. I don't see myself committing criminal acts, but a 51% threshold to sue me on civil shit sounds like a fucking nightmare. I'd rather just be liable for criminal stuff, not civil stuff. The assumption, I don't know if I agree with this assumption that criminal stuff poses a greater threat to somebody than civil stuff, because criminal stuff, by definition, has a much higher threshold for a prosecution than just losing a civil case. I don't think I don't think I agree with this, but maybe my feelings will change. Also, keep in mind, we're reading the Supreme Court's decisions to hold this, to stay the decision. No. To reject the decision from the lower court, I think, right? But hopefully within this decision, hopefully they talk about counterbalancing the interests of the American public of not having a criminal fucking president, okay? We'll see. I'm sure they write that in there somewhere. Ed Krasen has brain worms too. Wait, what did he say? RFK might have a shot, but not the best shot. There are too many Democrats who don't support him. Oh, how can you support RFK? My God. Jesus Christ. Ben throws it back to Steven. Why do you fucking people keep linking this? But the way the system works means civil is less serious than criminal. That's why criminal requires a higher threshold. No. No, I would be very careful with that. Criminal and civil are two different things, okay? But if I were to ask you, what do you think represents a greater threat to you? The criminal prosecution that could convict you of a Class E misdemeanor, or a civil case where you're being sued for $100 trillion, right? right? I want to eat the misdemeanor at that point, right? Wait, hold on. What is this real quick? Stupid shit.
Ukrainian cities because they lose leverage with Russia if they didn't do that, right? And it all also seems, next thing I'd say before throwing it back, that
throwing it back, bend over burgers, throwing it back, throwing it.
Okay. If you are broke, you are immune to civil cases as you are judgment proof. Can you not seek a judgment in a civil case? Is that true? I feel like you can get, because you're like overdue rent is a would be a civil thing, right? I'm pretty sure that like your ex landlords and shit could get a judgment against you and like garnish wages. The hesitation to execute the duties of his office fearlessly and fairly might result when a president is making decisions under a pall of potential prosecution. From McDonald v. United States, 579 U.S. 550. Okay, States. If there's no way to know the years by just reading this, right? Unless, I mean, I guess I could know. 571 means this is what case in what, the 90s. You can't just know. McDonald v. United States. Just kidding. Way later. 2016? Just kidding. 2000s. Okay. I guess you could just know the approximate volumes or whatever. Right? So, fuck all that. Okay. Oh, no. Yeah, okay. McDonald v. United States raises unique risks to the effective functioning of government. There is also a compelling public interest in fair and effective law enforcement. That's citing a case called Vance. Okay. Taking into account these competing considerations, the court concludes that the separation of powers. But wait, these competing considerations. Wait. Did they write up in here the consideration of not having a criminal president? Was that really addressed in here? Like, it might be in the public's interest to not have a president committing fucking crimes. Did we just? Is that not a consideration? Do we not care about that, or are we just? Maybe? Okay. I don't know. Maybe that's not relevant at this point yet. Okay. Taking into account these competing considerations, the court concludes that the separation of powers principles explicated in the court's precedent necessitate at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibility. Such an immunity is required to safeguard the independence and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution. At a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. Jesus, what is the threshold for that? At a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. Let's see. This is Nixon v. Fitzgerald, right? Is what that's referencing. Nixon v. Fitzgerald. Dangers of intrusion on the authority. Oh, wait. Government needs to show that applying a criminal prohibition to an act would pose no danger of intrusion on the presidential powers. As for a president's unofficial acts, there is no immunity. Although presidential immunity is required for official acts to ensure that the president's decision-making is not distorted by the threat of future litigation stemming from those actions, that concern does not support immunity for unofficial conduct. Clinton, 520 U.S. at 694 and number 19. The separation of powers does not bar a prosecution predicated on the president's unofficial acts. Okay, the first step in deciding whether a former president is entitled to immunity from a particular prosecution is to distinguish his official from unofficial actions. In this case, no court thus far has drawn that distinction, in general, or with respect to the conduct alleged in particular. It is therefore incumbent upon the court to be mindful that it is a court of final review and not first view. Zivotofsky v. Clinton, blah, blah, blah. Critical threshold issues in this case are how to differentiate between a president's official and unofficial actions, and how to do so with respect to the indictment's extensive and detailed allegations covering a broad range of conduct. The court offers guidance on those issues. When the president acts pursuant to constitutional and statutory authority, he takes official action to perform the functions of his office. Determining whether an action is covered by immunity thus begins with assessing the president's authority to take that action. But the breadth of the president's discretionary responsibilities under the Constitution and laws of the United States frequently makes it difficult to determine which of his innumerable functions encompassed a particular action. The immunity the court has recognized therefore extends to the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. So this would probably be the most generous reading, then, of how far out a presidential power can go. In dividing official from... This is basically like, I guess, like Trump's legal arguments in front of the Supreme Court were arguing for a few different things, and I think the thing that they were arguing for the most basically means that I'm talking about not just the core things the president do, but stuff all the way to the outer perimeter should be beyond criminal review, or there should be some presumptive immunity. So it sounds like the Supreme Court is agreeing with that it basically is going to the outer perimeter of what could constitute a presidential official action, essentially. In dividing official from unofficial conduct, courts may not inquire into the president's motives. In dividing official from unofficial... So remember, something I said before going into this is one of the difficulties of this case is that I believe that the Supreme Court was said to, and this was debated in oral arguments, is it's not even just that they're making rules on what can or cannot be ruled on, but what you're even allowed to consider or bring into evidence to justify challenging certain presidential actions has been called into question as well, which is what we're about to get into here. Jesus, hold on. Okay. Boom, boom, boom. Gotcha. In dividing official from unofficial conduct, courts may not inquire into the president's motives. Such a highly intrusive inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose. Just an allegation doesn't give the court the right to examine something, though, right? I could allege somebody raped somebody. That doesn't give the court the right to review that, or it doesn't give them. It doesn't mean that is going to come under review, right? There are other thresholds that have to be met, right? Like probable cause or. Nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. Otherwise, presidents would be subject to trial on every allegation that an action was unlawful, depriving immunity of its intended effect. With the above principles in mind, the court turns to the conduct alleged in the indictment. This just seems so wild. I'm so curious what the counter, how they're going to say, like, oh, but don't worry, this is how we're balancing the other side. This just seems so wild to me. Does this mean that if the president commits a crime as an official presidential action, it can't be prosecuted? For instance, the president orders by way of executive action the assassination of their political opponent. Well, they would have to claim that it's coming under the core power of a president, but they're about to give some examples, so we'll see. With the above principles in mind, the court turns to the conduct alleged in this indictment. Certain allegations, such as those involving Trump's discussions with the acting attorney general, are readily categorized in light of the nature of the president's official relationship to the office held by that individual. This is so crazy, too. This is what the, was it Jackson? One of the Supreme Court justices, or was it a reporter that wrote this in an article, is basically talking about how now, in order to prove these allegations, you're working with like, do they call it a three-legged stool? That like, okay, well, look, so Donald Trump goes on TV, and he says like, oh, I'm going to go talk to Pence. I'm going to go talk to Pence in order to rig the election. Then he goes and he talks to Pence about how to rig the electoral votes. And then somebody says, okay, well, yeah, we're going to sue the federal courts are going to press charges against Trump. Like the DA is going to file a case. And they're like, well, hold on. What are you going to take a case against him for? Because he literally just said, like, look, he's obviously talking to Pence here in order to like commit a crime. He's trying to rig the election. Okay. You're not allowed to consider Trump's motivations. He's still acting in his official capacity as president because he's allowed to talk about the electoral vote. That's part of the purview of the jobs of the president and the vice president. That's like, yeah, that just seems wild to me. Certain allegations, such as those involving Trump's discussions with the acting attorney general, are readily categorized in light of the nature of the president's official relationship to the office held by that individual. So like this makes it say are readily categorized, meaning every single conversation he has with the acting attorney general would be beyond review. You couldn't even use it for motivation. Or like you couldn't even examine that. Other allegations, such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public, present more difficult questions. The indictment alleges that as part of their conspiracy to overturn, let's say that something came out where Donald Trump is raping a woman, and then you find out, oh, Donald Trump talked to the FBI to send the FBI to go capture this woman to bring him to his office to rape. It's like, okay, well, we need to probe that. Wait, excuse me. Donald Trump is the executive. Okay. The Department of Justice serves under the executive branch where the president's the head of. The FBI is part of the DOJ. You can't review that. You can't even ask questions about that because Donald Trump is allowed to talk to the DOJ. He's allowed to talk to the FBI. It's literally his part of the core functionality of the executive. That's not reviewable. You can't even ask questions about that. Okay. Destiny, it makes sense. It's comparable to attorney-client privilege. Okay, Leon's Law. You're a lawyer guy. My understanding is one of the few times you're allowed to pierce the corporate or the attorney-client privilege is if you are using your lawyer to commit a crime, though. Is that not true? Like if you're talking to your lawyer, and you're like, hey, can you give me some advice on like how to commit a crime and all that? I'm pretty sure that if prosecutors can show that that's the case, I think they can pierce that privilege. I don't think you're allowed to do that. Wait, I can look this up real quick. No, man. Can you commit piercing attorney-client veil used to commit crime? Oh, the crime fraud privilege. Privilege exception. The crime fraud exception pursuant to section 90.5.2, there is no attorney-client privilege when the services of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit what the client knew was a crime or fraud. So the presidential immunity here seems to be stronger because you can't even, the fact that the president has a relationship with certain people means that it's beyond review. Like you would assume that it's a core thing. So it seems like what's being suggested for the president would be even stronger. But, okay. The indictment alleges that as part of their conspiracy to overturn the legitimate results of the 2020 presidential election, Trump and his co-conspirators attempted to leverage the Justice Department's power and authority to convince certain states to replace their legitimate electors with Trump's fraudulent slates of electors. So in the indictment, the part that they're referring to here in the indictment is Donald Trump threatened his acting attorney general that he would fire him if he didn't send out basically a fake letter saying, hey, we found election fraud. I think this was Rosen. Hey, we found election fraud, so you guys should like not certify your vote or send in the other slate of electors. Donald Trump threatened his acting attorney general that he'd fire him and replace him with like a coffee boy or some bullshit, some stupid shit. In order, if he didn't do this for him, that's included in the Jack Smith indictment. Oh, fuck. They say it right in here. My bad. According to the indictment, Trump met with the acting attorney general and other senior Justice Department and White House officials to discuss investigating purported election fraud and sending a letter from the department to those states regarding such fraud. The indictment further alleges that after the acting attorney general resisted Trump's requests, Trump repeatedly threatened to replace him. The government does not dispute that the indictment's allegations regarding the Justice Department involve Trump's use of official power. The allegations, in fact, plainly implicate Trump's conclusive and preclusive authority. The executive branch has exclusive authority and absolute discretion to decide which crimes to investigate and prosecute, including with respect to allegations of election crime. Then they cite to Nixon. I want to read that Nixon citation. I don't trust any of these citations. I'm so curious what was said here. 418 U.S. at 693 about exclusive authority and absolute discretion to decide which crimes to investigate and prosecute. And the president's management of the executive branch requires him to have unrestricted power to remove the most important of his subordinates, such as the attorney general, in their most important duties. Citing to Fitzgerald again, the indictment's allegations that the requested investigations were shams or proposed for an improper purpose do not divest the president of exclusive authority over the investigative and prosecutorial functions of the Justice Department and its officials. Because the president cannot be prosecuted for conduct within his exclusive constitutional authority, Trump is absolutely immune from prosecution for the alleged conduct involving his discussions with Justice Department officials. This sounds like, so they're not leaving this part up for interpretation. It sounded like earlier they were saying the lower courts need to distinguish between some things, but it sounds like for some of these they're just saying like, no, that's wild. Holy shit. The indictment next alleges that Trump and his co-conspirators attempted to enlist the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. In particular, the indictment alleges several conversations in which Trump pressured the vice president to reject states' legitimate electoral votes or send them back to state legislatures for review. Whenever the president and vice president discuss their official responsibilities, they engage in official conduct. Presiding over the January 6th certification proceeding, at which members of Congress count the electoral votes, is a constitutional and statutory duty of the vice president. The indictment's allegations that Trump attempted to pressure the vice president to take particular acts in connection with his role at the certification proceeding thus involve official conduct, and Trump is at least presumptively immune from prosecution for such conduct. I don't understand how broad this is. So, like, let's say, for instance, Trump says, I think that in the January 6th, I think that in January 6th, when we count the votes, we should have it as part of the ceremony. We should have 100 children being shot with AK-47s. Actually, let's bring them. Let's bring 100 children, line them up, shoot them with AK-47s, right? And then I've got I already bought the guns. I've already contacted the people. We've already adopted the show. Like, it'll be great, okay? You're saying that, like, okay, well, hold on. You can't talk about conspiracy to commit a crime or anything. He was talking to him about the January 6th stuff. This is part of his powers as the president, to talk about the January 6th stuff. Like, what I'm looking for here in the decision is, okay, fine. I think that any reasonable person, the most liberal, would agree that the president probably is due maybe some form of criminal immunity for, like, core executive powers. Maybe. I think that argument can be made. This, however, sounds so broad. Like, because they're not talking about Donald Trump was speaking as the president about the procedures of the electoral vote counting. They're saying that just the fact that he was having a conversation about it at all, and because of who he is and who the vice president is, everything within that conversation would fall under presumptive immunity from prosecution. Like, that's just a wild, yeah. But we'll see. Well, I'm sure they, yeah. We'll see what else is said here. Would it be fair to say that the ruling leans too heavy to the separation of powers and too little to the checks and balances? Maybe. I don't even know if we're saying like separation of powers here is, though. Typically, the idea of separation of powers and like criminal review on presidential actions, I don't think is traditionally thought of as part of our separation of powers. I could be wrong on that. I don't think this is a thing that most people even think about. But this type of like king making just seems very weird. But we'll see. We'll get into it. The question then becomes whether that presumption of immunity is rebutted under the circumstances. It is the government's burden to rebut the presumption of immunity. The court, therefore, remands to the district court to assess in the first instance whether a prosecution involving Trump's alleged attempts to influence the vice president's oversight of the certification proceeding would pose any dangers of intrusion on the authority and functions of the executive branch. I wonder what the standard is for to make that argument. So they're basically saying, okay, fine. If you want to review stuff criminally that Donald Trump told Pence in the January 6th stuff, you have to prove, the government first has to prove if that prosecution would basically fuck up how the executive branch functions, because now every future president is going to be scared of this sort of intrusion, essentially. No one should be able to hurt my Trumpy Trump. Good job. The indictment's remaining allegations involve Trump's interactions with persons outside the executive branch, state officials, private parties, and the general public. In particular, the indictment alleges that Trump and his co-conspirators attempted to convince certain state officials that election fraud had tainted the popular vote count in their states, and thus electoral votes for Trump's opponent needed to be changed to electoral votes for Trump. After Trump failed to convince those officials to alter their state processes, he and his co-conspirators allegedly developed and effectuated a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding. There's no way this is a part of the... There's no way, right? On Trump's view, the alleged conduct qualifies as official because it was undertaken to ensure the integrity and proper administration of the federal election. As the government sees it, however, Trump can point to no plausible source of authority enabling the president to take such actions. Determining whose characterization may be correct and with respect to which conduct requires a fact-specific analysis of the indictment's extensive and interrelated allegations. The court accordingly remands to the district court to determine in the first instance whether Trump's conduct in this area qualifies as official or unofficial. Jeez. Which facts we can consider will be important too, but we'll get to that, I'm sure. The indictment also contains various allegations regarding Trump's conduct in connection with the events of January 6th itself. The alleged conduct largely consists of Trump's communications in the form of tweets and a public address. The president possesses extraordinary power to speak to his fellow citizens and on their behalf, Trump v. Hawaii. So most of a president's public communications are likely to... That's the case we're talking about? Okay. Do I want to look up that? Is that really... Trump v. Hawaii. $585. Does the president speaking constitute a core power? Constitute a core power. So most of a president's public communications are likely to fall comfortably within the outer perimeter of his official responsibilities. There may, however, be contexts in which the president speaks in an unofficial capacity, perhaps as a candidate for office or party leader. How could you ever say that somebody running for re-election isn't speaking as a president? Like, to the extent that may be the case, objective analysis of content, form, and context will necessarily inform the inquiry. Snyder v. Phelps, 562 U.S. Whether the communications alleged in the indictment involve official conduct may depend on the content and context of each. This necessarily fact-bound analysis is best performed initially by the district court. The court therefore remands to the district court to determine in the first instance whether the alleged conduct is official or unofficial. And then just to remember the structure, you do your, it's district court. Is it district court, then court of appeals, then circuit court, then Supreme Court? Or is the court of appeals in the district, or in the, hold on, let me just have the structure down. District court, court structure, United States. Wait, boom, boom. Okay, you've got your district court. Okay, the circuit courts, that's the same thing as your court of appeals. Okay, Supreme Court of the United States. There are 13 circuits in the United States. There are more districts, right? There's not just, there are over 670 district court judges nationwide. Okay. Okay, so you've got your district courts. Those exist under your circuit courts. And then if something is appealed to from your circuit courts, you have your Supreme Court reviews it next. Okay. Presidents cannot be indicted based on conduct for which they are immune from prosecution. On remand, the district court must carefully analyze the indictment's remaining allegations to determine whether they too involve conduct for which a president must be immune from prosecution. And the parties in the district court must ensure that sufficient allegations support the indictment's charges without such conduct. Testimony or private records of the president or his advisors probing such conduct may not be admitted as evidence at trial. Oof, that's like a big memer. So that means that, so like if the president said something, I'm trying to imagine. If the president said something to Pence where he was like, listen, I'm going to give a big speech tomorrow to rise people up to go and like fight at the White House or fight at the Capitol building, and then you guys are going to overturn the election. Okay, that's great. Then he gives his speech the next day in the ellipses or whatever. If a court were to say, okay, hold on, we know this speech was given, you were literally trying to incite people to riot. We literally have you saying to Pence, then the court would say, sorry, hold on, excuse me. Donald Trump was speaking as a president to his vice president. You can't use that as evidence for another crime. So I feel like then if you're a president, as long as you're plotting crimes or you're conspiring in conjunction with doing an official act, this is the three-legged stool. Yeah, this is the three-legged stool that was brought up then during the oral arguments, that any crime that you've committed while you're doing an official act as president makes it immune for not only prosecution of that particular crime, that can't be used to talk about any other crime, which is interesting. Somebody said, yes, and if it's found out, then impeach and remove them. We're not talking about impeachment or removal here. Why would you bring that up? I don't understand why you would. You aren't invincible. You just have to impeach and remove them first. What about impeaching somebody all of a sudden means that the presidential conduct is now under criminal review? Is that going to be in here later? Dick killing spree? Or are you just talking out your ass? Maybe that'll come up later. We'll see. But I haven't seen them say anything about that yet. Trump asserts a far broader immunity. Trump asserts a far broader immunity than the limited one the court recognizes. Yeah, this is the limited one? Christ. Trump asserts a far broader immunity than the limited one the court recognizes, contending that the indictment must be dismissed because the impeachment judgment clause requires that impeachment and Senate conviction precede a president's criminal prosecution. Oh, this was another argument that had been floated that was beyond fucking stupid. We'll see if the court said that agreed with this. But the text of the clause does not address whether and on what conduct a president may be prosecuted if he was never impeached and convicted. See Article 1, Section 1. Historical evidence likewise lends little to support Trump's position. Well, that's good at least, I guess. Oh, so this is addressing that the judges are basically saying that you're fucking retarded, dick killing spree. So you literally just brought up the conspiracy theory that is now addressed right here. This idea was fucking stupid. Historical evidence likewise. The Federalist Papers on which Trump relies concerned the checks available against a sitting president. They did not endorse or even consider whether the impeachment judgment clause immunizes a former president from prosecution. Transforming the political process of impeachment into a necessary step in the enforcement of criminal law finds little support in the text of the Constitution or the structure of the nation's government. Oh, okay, cool. That was the thing that we were referring to. I said if you go back and you read the quotes, it doesn't seem like they were arguing that like you need to impeach somebody and then a criminal thing can happen or whatever. I don't think there's any. Yeah, that's bullshit. The government takes a similarly broad view, contending that the president enjoys no. Remember when they say the government here, they're talking about the prosecution essentially here. I think they're not talking about themselves. When they say the government, they don't mean like the Supreme. They're not including themselves in this. Okay. The government takes a similarly broad view, contending that the president enjoys no immunity from criminal prosecution for any action. On its view, as applied challenges in the course of the trial suffice to protect Article 2 interests, and review of the district court's decisions on such challenges should be deferred until after trial, but questions about whether the president may be held liable for particular actions consistent with the separation of powers must be addressed at the outset of a proceeding. Even if the president were ultimately not found liable for certain official actions, the possibility of an extending proceeding alone may render him unduly cautious in the discharge of his official duties. From the Nixon v. Fitzgerald case, the Constitution does not tolerate such impediments to the effective functioning of government. Jesus. This case poses a question of lasting significance. When may a former president be prosecuted for official acts taken during his presidency? In answering that question, unlike the political branches and the public at large, the court cannot afford to fixate exclusively or even primarily on present exigencies. Exigencies? That just means basically circumstances and everything, right? Hold on. Exigencies. An urgent need or demand on present urgency. Okay, gotcha. Present urgency. Okay. Enduring separation of powers principles guide our decision in this case. The president enjoys no immunity for his unofficial acts, and not everything the president does is official. The president is not above the law. I don't understand. I don't understand when they say separation of powers. I wasn't aware that like criminal courts are generally considered part of the separation of powers. The criminal court is not supposed to be a check on presidential power. The criminal court is not supposed to be a check on any part of the government. In my understanding, that's just not. I don't understand that. Separation of powers generally refers to the Supreme Court checking your legislative and your executive checking your legislation, Supreme, et cetera, whatever, right? I don't understand the for separation of powers here. We're talking about the executive investigating the president. What are we separating? I don't understand what the separation is here. I don't understand what that means, but maybe they'll explain it more. Yeah, I'm not sure. Checks and balances are not separation of powers. When people say separation of powers, wait, I thought checks and balances was a core part of separation of powers. Well, let's check, I guess. Separation of powers. It's a division of government into branches, each with separate and independent powers and responsibilities, so that the powers of one branch are not in conflict with the other. The typical division into three branches of government, sometimes called. Okay. According to the principle of checks and balances, each of the branches of the state should have the power to limit or check the other two, creating a balance between the three separate powers of the state. Each branch's efforts to prevent either of the other branches from becoming supreme form part of an eternal conflict, which leaves people free from government abuses. Immanuel Kant was an advocate of this. Who cares? Loser. Okay. Enduring separation of powers principles guide our decision in this case. The president enjoys no immunity for his unofficial acts, and not everything the president does is official. The president is not above the law, but under our system of separated powers, the president may not be prosecuted for exercising his core constitutional powers, and he is entitled to at least presumptive immunity from prosecution for his official acts. That immunity applies equally to all occupants of the Oval Office. Does this mean like all of the cabinet people, like all the chief of staff, like all of that? Is that what that means there? Does that go down to like staffers or? To all occupants of the Oval Office? Is that just a cute way of saying president? Okay. This opinion, this is the majority opinion. This is a 6-3 rule, and it was penned by Roberts, in which Thomas, Alito, Gorsuch, and Kavanaugh joined in full, and in which Barrett J. joined, except as to Part 3C. Thomas filed a concurring opinion. Barrett filed an opinion concurring in part. Sotomayor filed a dissenting opinion in which Kagan and Jackson joined, and Jackson filed a dissenting opinion. I could just be remembering history wrong, but I feel like people saw Gorsuch as an okay pick, Kavanaugh maybe as a bit unhinged, but I thought Amy Coney Barrett was supposed to be the most unhinged pick based on her past, but I feel like she's given like the most chill opinions just on the few cases that I've read, but I don't know. Okay, let me use the restroom real quick, 1 second. Okay. Jesus, the fuck is this? Hold on. The 6th at 5 p.m. Ugh. Is this real? Hold on. Bridges at 3 p.m. on Saturday the 6th. 100% a real thing. Okay. Opinion of the court. Supreme Court of the United States. Donald J. Trump petition of the United States on writ of certiorari. Certiorari, I think is how you pronounce it. Okay. Certiorari. 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 Chief Justice Robert Scalia, the opinion of the court. This case concerns a federal indictment of a former president of the United States for conduct alleged to involve official acts during his tenure in president. We consider the scope of a president's immunity from criminal prosecution. Wait, so what are we reading? What is this? That's the conservative argument. I'm just supposed to assume that this is the majority opinion coming first? Okay. I like how Destiny said this was a new content direction when it's the same exact boring reading he has done for months. Bring back the memes. Goodbye, permaban. See ya. Complain about content, just go watch somebody else, okay? From January 2017 until January 2021, Donald J. Trump served as President of the United States. On August 1st, 2023, a federal grand jury indicted him on 4 counts for conduct that occurred during his presidency following the November 2020 election. The indictment alleged that after losing that election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the election results. So this is written by Roberts then, right? You said 30 days about... Yeah, but I can't do time ban on YouTube, so you just get permabanned. According to the indictment, Trump advanced his goal through 5 primary means. First, he and his co-conspirators used knowingly false claims of election fraud to get state legislators and election officials to change electoral votes for Trump's opponent, Joseph R. Biden Jr., to electoral votes for Trump. Second, Trump and his co-conspirators organized fraudulent slates of electors in 7 targeted states and caused these fraudulent electors to transmit their false certificates to the vice president and other government officials to be counted at the certification proceeding on January 6th. Third, Trump and his co-conspirators attempted to use the Justice Department to conduct sham election crime investigations and to send a letter to the targeted states that falsely claimed that the Justice Department had identified significant concerns that may have impacted the election outcome. Fourth, Trump and his co-conspirators attempted to persuade the vice president to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. And when that failed, on the morning of January 6th, they repeated knowingly false claims of election fraud to gathered supporters, falsely told them the vice president had the authority to and might alter the election results, and directed them to the Capitol to obstruct the certification proceeding. Fifth, when a large and angry crowd violently attacked the Capitol and halted the proceeding, Trump and his co-conspirators exploited the disruption by redoubling efforts to levy false claims of election fraud and convince members of Congress to further delay the certification. Based on this alleged conduct, the indictment charged Trump with 1, conspiracy to defraud the United States in violation of 18 U.S.C. 371, 2, conspiracy to obstruct an official proceeding in violation of 1512 subsection K, 3, obstruction of an attempt to obstruct an official proceeding in violation of Section 1512, subsection C2, Section 2, and 4, conspiracy against rights in violation of Section 241. Trump moved to dismiss the indictment based on presidential immunity. In his view, the conduct alleged in the indictment, properly characterized, was that while he was president, he made public statements about the administration of the federal election, 2, communicated with senior Justice Department officials about investigating election fraud and about choosing the leadership of the department, 3, communicated with state officials about the administration of the federal election and their exercise of official duties with respect to it, 4, communicated with the vice president and with members of Congress about the exercise of their official duties regarding the election certification, and 5, authorized or directed others to organize contingent slates of electors in furtherance of his attempts to convince the vice president to exercise his official authority in a manner advocated for by President Trump. The motion to dismiss indictment based on presidential immunity in whatever bullshit, referring to, I guess, a motion, Trump argued that all of the indictment's allegations fell within the core of his official duties, and he contended that a president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibilities to ensure that he can undertake the especially sensitive duties of his office with bold and unhesitating action. Trump contends that the indictment stretches Section 1512 far beyond its natural meaning. Brief for petitioners, we explained, and Fisher covers acts that impair the availability or integrity. Okay. The district court denied the motion to dismiss, holding that former presidents do not possess absolute federal criminal immunity for any acts committed while in office. The district court recognized that the president is immune from damages, liability, and civil cases to protect against the chilling effect such exposure might have in the carrying out of his responsibilities. See Nixon v. Fitzgerald. But it reasoned that the possibility of vexatious post-presidency litigation is much reduced in the criminal context in light of the robust procedural safeguards attendant to federal criminal prosecutions. So that's essentially the argument that I was making. Like, it's not like you can just charge anybody with a crime, right? You've got to get like a whole grand jury. You've got to collect evidence. You've got to indict. There's like a whole process here, right? Wait, hold on, shit. Is Bridges a real thing? Okay. The district court declined to decide whether the indicted conduct involved official acts. The D.C. Circuit affirmed. So the district court was our first court, appealed to the D.C. Circuit Court, and now we're dealing with the writ of certiorari to the Supreme Court for their review. Okay. Citing Marbury v. Madison, the court distinguished between two kinds of official acts, discretionary and ministerial. It observed that although discretionary acts are only politically examinable, the judiciary has the power to hear cases involving ministerial acts that an officer is directed to perform by the legislature. From this distinction, the D.C. Circuit concluded that the separation of powers doctrine, as expounded in Marbury and its progeny, necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the Congress's laws. In the court's view, the fact that Trump's actions allegedly violated generally applicable criminal laws meant that those actions were not properly within the scope of his lawful discretion. The D.C. Circuit thus concluded that Trump had no structural immunity from the charges in the indictment. So essentially saying here that separation of powers means that if the president is being accused of breaking a law, it's essentially because laws come from Congress, that the president would be breaking a law from Congress, so the Supreme Court would have the ability to review that, basically? Or they're agreeing here. They're citing Marbury, I guess, to essentially further that argument. Courts view the fact that Trump's not eligible. But the D.C. Circuit Court says that since Trump's actions had nothing to do with his role as president, then it's not applicable here, basically. Applicable. I keep saying applicable. Applicable. Like the district court, the D.C. Circuit declined to analyze the actions described in the indictment to determine whether they involved official acts. We granted certiorari to consider the following question. Whether and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? So none of the lower courts right now, have reviewed or have answered the question of were any of his acts official acts as president, basically. Destiny, genuine question. Presidents have not been charged over official acts for years. Doesn't this ruling just maintain the status quo? No. That is a dog shit, bullshit, stupid fuck answer, okay? Anybody that furthers that is being disingenuous. The idea that just because somebody hasn't been charged with a thing means that nobody ought to be charged with a thing misses one key component of how customs are developed, and that's that nobody has done the particular thing because they have the assumption that they would be charged with a particular thing. When people say, and there's a very common argument that's furthered in favor of Trump, oh, nobody's been charged with this before, therefore we should never charge somebody with it. The reason why nobody's been charged with it might be because the President of the United States has always operated with the assumption that if he did do it, he would be charged for it. So he doesn't do that particular thing. Just because a person in a certain role hasn't committed a crime and therefore hasn't been charged with a crime doesn't mean that all future people could commit crimes because no charges have happened yet, okay? Okay. Jesus Christ. Okay. Yes, but is what he did even defined as a crime when he did it? Yes, there are 4 criminal statutes that are cited in the Jack Smith case for crimes that he are alleged to have broken. Okay. This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. We are called upon to consider whether and under which circumstances such a prosecution may proceed. Doing so requires careful assessment of the scope of presidential power under the Constitution. We undertake that responsibility conscious that we must not confuse the issue of a power's validity with the cause it is invoked to promote, but must instead focus on the enduring consequences upon the balanced power structure of our republic. When he says we undertake that responsibility conscious that we must not confuse the issue of a power's validity with the cause it is invoked to promote, this seems like it's getting at the idea that I said earlier. It's like, okay, well, hold on. You can't just say like, oh, I was talking to Pence when we were, conspiring to commit crimes, so it should be fine because it's under my core powers. They're saying, okay, well, hold on. Just because that particular power to confer with your vice president over these things, is valid, doesn't mean that you can just invoke it to protect any behavior, right? We'll see how they balance that here, basically. Ooh, sorry, hold on. The parties before us do not dispute that a former president can be subject to criminal prosecution for unofficial acts committed while in office. See, it's a tape recording, TR, I don't know, oral argument, blah, blah, blah. They also agree that some of the conduct described in the indictment includes actions taken by Trump in his unofficial capacity. They disagree, however, about whether a former president can be prosecuted for his official actions. Trump contends that just as a president is absolutely immune from civil damages liability for acts within the outer perimeter of his official responsibilities, he must be absolutely immune from criminal prosecution for such acts. Brief from petitioner, he's citing other things. Trump argues that the bulk of the indictment's allegations involve conduct in his official capacity as president. Although the government agrees that some official actions are included in the indictment's allegations, it maintains that a former president does not enjoy immunity from criminal prosecution for any actions, regardless of how they are characterized. We conclude that under our constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. At least with respect to the president's exercise of his core constitutional powers, This immunity must be absolute. As for his remaining official actions, he is also entitled to immunity. At the current stage of proceedings in this case, however, we need not and do not decide whether that immunity must be absolute or instead whether a presumptive immunity is sufficient. Article 2 of the Constitution provides that the executive power shall be vested in a President of the United States. The President's duties are of unrivaled gravity and breadth, Trump v. Vance. They include, for instance, commanding the armed forces of the United States, granting reprieves and pardons for offenses against the United States, and appointing public ministers and consuls, the justices of this court, and officers of the United States. He also has important foreign relations responsibilities, making treaties, appointing ambassadors, recognizing foreign governments, meeting foreign leaders, overseeing international diplomacy and intelligence gathering, and managing matters relating to terrorism, trade, and immigration. Domestically, he must take care that the laws be faithfully executed, and he bears responsibility for the actions of the many departments and agencies within the executive branch. He also plays a role in lawmaking by recommending to Congress the measures he thinks wise and signing or vetoing the bills Congress passes. No matter the context, the President's authority to act necessarily stems either from an act of Congress or from the Constitution itself. In the latter case, the President's authority is sometimes conclusive and preclusive. When the President exercises such authority, he may act even when the measures he takes are incompatible with the expressed or implied will of Congress. The exclusive constitutional authority of the President disables the Congress from acting upon the subject. And the courts have no power to control the President's discretion when he acts pursuant to the powers invested exclusively in him by the Constitution. If the President claims authority to act, but in fact exercises mere individual will and authority without law, the courts must say so. In Youngstown, for instance, we held that President Truman exceeded his constitutional authority when he seized most of the nation's steel mills. But once it is determined that the President acted within the scope of his exclusive authority, his discretion in exercising such authority cannot be subject to further judicial examination. The Constitution, for example, vests the power to grant reprieves and pardons for offenses against the United States in the President. So something that would be very interesting here, I don't know if they'll address it in here, is one of the examples that was given was, okay, well, the President of the United States exclusively has the power, and it is literally granted explicitly in the Constitution to grant pardons. What if the President accepts a bribe for the pardon, right? This is what the three-legged test was memed about. Well, let's say that he accepts a bribe. How can I even prove that that was a crime if I can't even examine his acceptance of the bribe? Because the act that it was tied to was pardoning somebody, basically, right? If you wanted to examine that in court, you would go to court and you'd say, hey, I want to prosecute Trump because this guy gave him $1,000. Like, why do you want to, how can you prosecute somebody for taking money? Well, because he gave him $1,000 and he wanted him to do something. Right? What do you mean gave him $1,000 and wanted him to do something? Well, he gave him $1,000 to bribe to pardon somebody. Pardoning? Whoa! Sorry, sir. That's an official part of the President. I didn't even hear what you just said. I'm sorry. Excuse me? Like, how would you even prove that crime if you can't even talk about the core function of what the President's doing? It seems like it would make it impossible. This is the three-legged stool argument. How would you even do it? But we'll see. We'll see. That must be addressed in here, so we'll see. The Constitution, for example, vests we just read this, the power to grant reprieves and pardons for offenses against the United States in the President. During and after the Civil War, President Lincoln offered a full pardon with restoration of property rights to anyone who had engaged in the rebellion but agreed to take an oath of allegiance to the Union. But in 1870, Congress enacted a provision that prohibited using the President's pardon as evidence of restoration of property rights. Chief Justice Chase held the provision unconstitutional because it impaired the effect of a pardon and thus infringed the constitutional power of the executive. To the executive alone is entrusted the power of pardon, and the legislature cannot change the effect of such a pardon any more than the executive can change a law. The President's authority to pardon, in other words, is conclusive and preclusive, disabling the Congress from acting upon the subject. When you say conclusive and preclusive, conclusive meaning that the President decides it, and preclusive meaning no one else can, right? That's essentially what we're saying, right? Destiny, the act of bribery is separate from the act that he would commit for the bribe. No, it's not. Accepting money on its own is a crime that would be outside the President's duty. No, accepting money is not a crime. What are you talking about? No, it's not. Okay. Some of the president's other constitutional powers also fit that description. The president's power to remove and thus supervise those who wield executive power on his behalf, for instance, follows from the text of Article 2. We have thus held that Congress lacks authority to control the president's unrestricted power of removal with respect to executive officers of the United States whom he has appointed. They're citing other cases here. Citing the president's exclusive power removal in executive agencies as an example of conclusive and preclusive constitutional authority. Okay. The power to control recognition determinations of foreign countries is likewise an exclusive power of the president. Congressional commands contrary to the president's recognition determinations are thus invalid. Yeah, it might not be three-legged stool. It might be one-legged stool. I might be citing that meme wrong. Congress cannot act on, and courts cannot examine, the president's actions on subjects within his conclusive and preclusive constitutional authority. It follows that an act of Congress, either a specific one targeted at the president or a generally applicable one, may not applicable. Is it? Can it be said both ways? Applicable one, may not criminalize the president's actions within his exclusive constitutional power. Neither may the courts adjudicate a criminal prosecution that examined such presidential actions. We thus conclude that the president is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority. Hello?
Civil law. I saw you were discussing Constitution. I thought maybe I dropped off. Wanted.
Oh, I'm on page 20 of 120, so I'm just reading through the Supreme Court decision.
Okay.
Do you have you read it all, or did you read through parts of it, or?
I read through the majority opinion.
Any feelings?
Yeah, I'm a little confused. The Supreme Court didn't give enough guidance on what happens if it falls into this middle ground category. So basically, the president's acts can fall into one of three categories. The core acts, which are constitutionally delegated.
Yep.
They are
the perimeter acts, and then
which
the
are just him.
Unofficial ones,
I
think, right? It's like core acts,
yeah.
There's perimeter acts, and then there's unofficial actions. So actions essentially as a private
Right.
citizen or whatever, yeah.
Yeah, correct. So the middle part is where it's a little bit vague because they say it's presumptively, he's presumptively immune, but they don't really give a very strong test for how to determine whether there really is immunity or not. So it's a little vague in the middle part.
Sure. I haven't gotten through. I don't think I've even read through because this is the majority of your opinion of the full thing. I'm only on page 17, but I don't even know if the core thing is spelled out well with the way that they're doing this criminal, with the way that they're doing this immunity. So I'm curious. Let's say I go up to the president of the United States and I say, "Hey, listen, can you pardon this guy? I'm going to bribe you. I'll give you $1 million." Is that a thing that could never be criminally prosecuted?
For the pardon itself, yes. For the bribe, no.
What am I bribing for if you can't review the pardon?
Yeah, the bribe itself, I think you could.
What is the bribe? What is
itself,
the? No. I can't review the president to see if he actually did the thing though, or if he had any intention of doing the thing though. Wouldn't the action just be taking money?
That's a fair point. So it might be the case that in that case the bribe would be legal.
So then it feels like, so what if I go to the president is the commander in chief, what if I pay him $1 million to go and assassinate some dude I don't like in Britain? Is the president like for sale? There's like no way to review any of those actions. I feel like commander in chief is probably core. I don't know. Because I know that some people are probably going to come away from this thinking like, man, what is the outer perimeter of the president's duties? But I'm thinking like, man, permanent, like absolute criminal immunity, even from the core duties is kind of weird. And the fact that you can't even consider motivations or anything. But maybe, I don't know, maybe they'll discuss it in here. But
the not considering motivations isn't that atypical when we look at, for example, just a standard roadside stop. We don't ask the police's motivation in doing the stop. We simply ask whether or not they have a legal basis to do the stop. So not looking at motivations isn't that odd.
We're not talking about the prosecutor here, though, or the law enforcement officer, though. Aren't we talking about the person being criminally indicted or being charged with a crime? Isn't the motivation there pretty important?
Well,
In fact, I'm sorry. Actually, I wouldn't. I'm sorry. The motivation isn't important. Isn't the motivation of the utmost important? Isn't that where our mens rea comes from for a criminal act?
No, not strictly speaking. Motive is never an element of the crime. You never have to prove motive. So
not
motive
maybe
is
not
nice to
motive,
have,
but like
it's
how do
never
you
required.
how do you separate like motive from like state of mind? I guess.
Well, the difference between intent and motive is the intent is the desire to do the thing. The motive is the reason why you're doing the thing. So to use an example, if I go to rob a bank, my intent is to rob the bank. My motive is unclear. Am I doing it for the money? Am I doing it for fame? Am I doing it because I'm trying to impress a girl? So there's a difference between my desire to do the act and my reason for doing the act.
You can never use conversations that might have been subpoenaed or obtained prior to robbing the bank to establish the intent.
You can typically, but here they're not allowing that. So it is an exception to the general rule.
Okay, yeah, it's going a bit further. It feels
Yes,
like
that's true.
Yeah, it feels like there's a lot of stuff then that I think we could very clearly. But like I said, I've only gotten through page 17. So okay. Okay. But of course, not all of the president's official acts fall within his conclusive and preclusive authority. As Justice Robert Jackson recognized in Youngstown, the president sometimes acts pursuant to an express or implied authorization of Congress, or in a zone of twilight where he and Congress may have concurrent authority. The reasons that justify the president's absolute immunity from criminal prosecution for acts within the scope of his exclusive authority, therefore, do not extend to conduct in areas where his authority is shared with Congress. We recognize that only a limited number of our prior decisions guide determination of the president's immunity in this context. That is because proceedings directly involving a president have been uncommon in our nation, and decisions of the court in this area have accordingly been rare and episodic. To resolve the matter, therefore, we look primarily to the framers' design of the presidency within the separation of powers, our precedent on presidential immunity in the civil context, and our criminal cases where a president resisted prosecutorial demands for documents. Section 1. The president occupies a unique position in the constitutional scheme as the only person who alone composes a branch of government. The framer has sought to encourage energetic, vigorous, decisive, and speedy execution of the laws by placing in the hands of a single constitutionally indispensable individual the ultimate authority that, in respect to the other branches, the Constitution divides among many. I'm sorry, I'm being so pedantic here, but is that necessarily true? Couldn't you argue, theoretically, couldn't you get rid of every single judge except for one Supreme Court justice who does every single federal case? Couldn't you theoretically do that?
The Constitution only requires that there be a Supreme Court and a Chief Justice, but the Constitution also does not give the Supreme Court original jurisdiction for many cases. So you could have only a Supreme Court, but if you did that, they wouldn't be able to hear a lot of federal cases.
And so constitutionally original jurisdiction is prohibited?
Yes.
Okay. All right. And then, sorry for chat. Original jurisdiction means that the Supreme Court can only hear a case on appeals that it was considered by a lower court first, not that they can be the first ones to hear any case ever, correct?
Correct. They have
okay.
very little authority to hear cases as the trial court.
Mm-hmm. Okay. Well, let's see. Enhanced with single constitutional... Okay. Okay. They deemed an energetic executive essential to the protection of the community against foreign attacks, the steady administration of the laws, the protection of property, and the security of liberty. The purpose of a vigorous and energetic executive, they thought, was to ensure good government, for a feeble executive implies a feeble execution of the government. The framers accordingly vested the president with supervisory and policy responsibilities of utmost discretion and sensitivity. He must make the most sensitive and far-reaching decisions entrusted to any official under our constitutional system. There accordingly exists the greatest public interest in providing the president with the maximum ability to deal fearlessly and impartially with the duties of his office. appreciating the unique risks to the effective functioning of government that arise when the president's energies are diverted by proceedings that might render him unduly cautious in the discharge of his official duties, we have recognized presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by our history. One thing that I hope they address in here, I don't know if they will, but they keep using this phrase, unduly cautious. Not all caution is undue. Some caution is good. I would argue in the United States, the vast majority of criminal statutes represents good caution, right? That you would want to be duly cautious not to rape somebody because you might be breaking a law, or not to murder or steal because you might be breaking a law. I hope they get into what the unduly cautious part is here, because there might be, maybe it's good, for instance, I personally, now, I'm not as imaginative as Trump's legal team, but I can't imagine a case where the president of the United States would need to rape somebody as part of his core constitutional duties. So if he had to consider that as part of his job, I think that the criminal statute, they're saying hey, listen, that's a criminal thing. You probably can't rape people. You shouldn't do that. That would be a good amount of caution to have him consider, right? Okay, well, fuck, if I do this, it's actually against the law. Maybe I should consider that, But I could also think of some things that are unduly burdensome that you wouldn't want a president, for civil litigation, I would agree. You don't want a president okay, fuck, we need to do COVID lockdowns, otherwise the country will fall apart. But if I do this, some business owners might sue me personally. I might get fucked, right? I can understand the civil immunity. It makes a lot of sense. I don't know as much if I agree with the criminal immunity, except in some cases, but we'll get there, I guess. In Nixon v. And then one question, I see this typed in chat a lot. I don't have a strong opinion yet, but one thing that keeps coming up is Watergate. Would Nixon have been liable for Watergate under these particular, under this interpretation of the court as criminal immunity? But who knows? We'll see.
I mean, I would think so, because in that case, he was bugging the offices of his political opponents as part of a campaign. So I'm not
so
sure
one
how
thing,
that
so
would tie into
the
presidential duty.
I understand what you're saying, but so this is where the really confusing part comes in, right? I don't know any of the details of Watergate, but let's say that Nixon requested his FBI to investigate and had the FBI go and bug it. That is literally a core power of the president that would, by this court's argument, be beyond review or consideration. So how would you even call that into question? Because it seems like it would be beyond.
You absolutely wouldn't, and that's a great thing to identify, Stephen. Keep in mind that Nixon was being investigated more for the obstruction component than necessarily being involved in the robbery itself. It's more of the crimes afterwards, where he recruited members of the actual government, right? The White House counsel and others. And so I don't see why Nixon's did anything wrong under that standard. And certainly if he directly ordered.
Sure. Or careful, not even, we wouldn't say he didn't do anything wrong, but he didn't do anything reviewable, right? So whether it was wrong or not, we have no way of even knowing, right?
If you are absolutely immune from something, are you doing anything illegal?
Well, not illegal, but wrong. I'm just saying because you said the word wrong.
You can't be punished for it, right?
Yeah, you can't be punished for it.
And this is where, by the way, all of the hypotheticals about SEAL Team 6 and assassinations are absolutely on point. If you notice the example used by the court of a core executive power, it is the communications that the president has with the Department of Justice.
Yeah, sure.
If the president ordered an individual in the Department of Justice to kill a rival, that would be the same kind of communication. What would be different about that communication that would be amenable to criminal process and indictment?
Sure.
There's absolutely no way to distinguish it.
Do special counsels, are those always at the discretion of the DOJ, or can there be a special counsel that comes from Congress?
There's a case called Morrison v. Olson, which had to do with the independent counsel statute, but that's been phased out. Mm-hmm. And that was still part of, as interpreted, still part of the executive branch, just not immediately fireable by the president. And there was other layers of review, but nowadays all special counsels are employees of the Department of Justice and are bound by their policies and can be fired.
Gotcha. So then under this for core powers, basically any communication or any appointments that the president makes in the executive, we would say is probably a core power, 100%. Right? So if the president felt like he was being investigated unfairly by any part of the DOJ or any part of he could very easily just fire and move, explicitly say, he's I know you guys are investigating me, you're all fired and I'm bringing new people. And that would be unreviewable by any criminal court, right?
Yes. evidentiarily it could not be used to establish other crimes, and it itself, you'd be immunized from it. And if you had any kind of like helpers or accomplices, obviously you could pardon them to the extent that they were committing federal crimes. And if he were impeached for those efforts and removed from office, he still wouldn't be amenable to criminal indictment. That's more immunity than Trump was asking for. This court was reviewing Trump's ridiculous argument under the impeachment judgment clause that in order to indict him for official acts, they had to first impeach him and then remove him. They went one step further than what Trump asked for and said, even if you impeach him, even if you remove him, you cannot indict him for any official acts. And those can be as broad as using the bully pulpit. You see them considering like just general public statements to the public as being contained within, or possibly contained, conceivably contained as official action. It is so broad. It is an insane rule.
How do you get rid of a federal judge? Is that a executive power or congressional power, or
impeachment?
Get rid of a judge, you'd impeach him and remove him.
So for federal judges? So when you say impeachment, that it has to be through Congress, basically?
That's correct.
Yeah. Okay. All right.
And
I think it's happened like 9 times total.
Okay.
One other thing. Notice there the total lack of coherence in this theory. The opinion goes out of its way to say the president is a branch unto himself. He is the executive. That's a unitary theory of executive power. If he is the executive branch and the executive power, it's all part of his power, why doesn't this immunity extend to every member of the executive branch? Why is it that the president is the only one under this theory that has absolute criminal immunity to this extent? Why wouldn't that apply to every other member? Maybe because there's zero history and tradition.
That's the wrong way around, I think.
No. Because think about it. If the executive branch, if he's a branch unto himself, how can he give away less power than he has? How can he give away or delegate some power, that's separate from the nature of his power?
We already have like a structure for this, right? You would just say that any person that's acting in the branch would always just say like, oh, well, the president ordered me to do this. And then that would essentially make it beyond review, right?
And the president's authority contains in it must. Why wouldn't it contain all of the protections of the president's authority?
That's not quite right, because most of the executive is delineated by statute, at which point you're in a slightly different category because it's not a core constitutional interest. So if you're just talking about an employee working in a random agency, that agency exists because of a statute, not because of inherent power of the president.
The DOJ exists by virtue of its statute, and notwithstanding that fact, when the president makes orders to the Department of Justice, that has been described as a core executive power.
When he's talking to the Attorney General, who is a senior advisor at least, yes.
Hang on a second. But you agree the Attorney General is a creature of statute. His authorities are made from an act of Congress. And so it's not this constitutional statute distinction, because what has been described as a core feature of the executive power has been communications to a statutorily created agency, namely the Department of Justice. And so I have no reason to think that like the basis of distinguishing the authority here is between statute and constitutional authority, or it's so broad under the take care clause or the general power of the executive to remove his officers, that it would encompass any communication or any action within the executive branch. There's no theory here. There's no history here. There's no text in the Constitution that references absolute immunity. These were smart guys, these founders. They knew how to write immunity clauses. They already wrote immunity clauses. They knew how to do it. And this court has abandoned its analytical framework of supposed textualism, supposed originalism for results. It wants to protect Donald Trump, and so that's what it did. And it's made a road to authoritarianism and tyranny, frankly. This is a really bad ruling. It's horrible. And anyone who defends it doesn't really stand for American principles.
Well, I appreciate being thrown under the bus that hard before I could even offer a contra idea, but okay. Well, but I will note that the ruling.
Well, let him.
Yeah, if I believe the ruling is correct, that I don't love America is a pretty harsh position to put me right from the start.
Well, I guess I'm asking you a direct question now. Do you support this ruling?
In large parts, yes, but I'm still vague a little bit on the middle part, as I expressed earlier.
That's not good enough for me.
Well, that's tough, because I don't have a firmer position yet. I haven't thought it all the way through, man.
If you're equivocal about whether or not you think the president of the United States could have this level of immunity, where essentially all he would have to do is very easily come up with some official act intermediary. And I can't think of where this ends. Honestly, think about it. If you had an order, I order my FBI agent to go and sexually assault someone, and that act itself, that ordering of the person to go do a most heinous act is unreviewable. Where does it stop? Where are these pro forma excuses that, oh, this is law enforcement purpose, this is national security purpose? This is the stuff.
Well, here, let him
of
answer. What is
tyranny.
it? What's the answer to that?
Well, I mean, there's a couple things that I have to respond to. With respect to the idea of the Attorney General, I will note that the Constitution does designate the idea of principal officers that the president has the ability to appoint. So there is a difference in the Constitution between, for example, the Attorney General and just a rank person who exists at the DOJ. The Constitution does treat those differently. With respect to the idea of immunity, then you're correct that the Constitution doesn't say that. And even the Supreme Court points that out, that it doesn't say that. But they're concerned about the power
About
and
policy.
separation of powers.
Wait,
I'm sorry.
They're concerned about policy.
Okay. I will simply note that I let you speak for quite a while
I
and
apologize.
you interrupted me.
Yeah.
Okay. So we can press on to other things because I lost my train of thought.
You lost your train of thought. You're defending absolute immunity. You were in the middle of saying that.
First of all, no, I wasn't. Because as I said at the very start, I'm a little unclear on the middle part with respect to the official acts as opposed to core acts. And then you said that wasn't good enough.
Well, so
And
here's
I'm
like
still
the
unclear
question
on
I
that
guess I
part.
would have for you. So we agree then. So we're going core Constitution, right? The Constitution itself spells out that the president shall appoint an attorney general, right? We all agree with that, right? So,
It says that
right.
he appoints principal officers, but I don't know why that's a distinction that matters.
I'm just
Where-
I'm not I'm
yeah.
just laying out the core just so we're on agreement here, right? So we agree that the president can appoint an attorney general, right?
That's correct.
We agree that the Department of Justice exists, that the FBI is a part of that, right? If the president himself, so the first question, if the president himself goes to the attorney general and he has a conversation about how to enforce the law, or a conversation, I guess really at all, with his attorney general, and in that conversation, he says, hey, I really don't like civil rights. I want all of my FBI officers to rape every single black person that they see. Okay, that's a new thing I want, right? And then let's say FBI officers start doing that. Obviously, the Congress, they start getting in trouble legally. And then somebody says, well, where did this come from? Do you agree, two parts? One, that the president was performing a core function of the presidency, and that two, it shouldn't be criminally reviewable? Or do you think there's some way, looking at this Supreme Court decision, that would allow you to review that decision for uncivil law?
I would say no, because I don't see how the president is chief executive, has the ability to enforce the law. So I'm not sure how that order would be in
Wait,
furtherance
you
of
don't
that
know how the
purpose.
president has the ability to enforce the
Wow,
law?
amazing. I got 5 words in and I got interrupted again. It's
Sorry, hold
almost
on.
like the question was asked to me, Pisco.
Yeah, wait, okay, hold on. You're saying that you don't understand how that order would be enforcing the law, right?
No, it wouldn't be enforcing the law because it's not part of the function of taking care that the law be faithfully enforced to give that order to an FBI official.
But are we able to
It's not
review?
part of the law
What?
enforcement purpose.
That is preposterous. So the president of the United States absolutely enforces the law. He's the chief executive.
I know, I said that.
So when the president makes an order, are you suggesting that that doesn't have the force of law or isn't pursuant to his duties under the take care clause?
No, not necessarily, no. Because just because he has the power to order the FBI to do things that would be part of taking care, it doesn't necessarily imply that every order is part of that function. He could give obviously something that's completely not part of that function.
Okay, wait.
He
So
could
wait.
order an FBI official to do act.
That means he has to be
Wait,
amenable to
way.
law.
No, wait.
That
Okay,
means-
I hold on. I think that's a good point. But how can we even begin to distinguish if his decisions aren't able to be reviewed?
Well, the Supreme Court does talk about the delineation between official acts and unofficial acts, which they spend much more verbiage on.
What do they
This wouldn't
say?
be unofficial. This is official. This is a core function. You're ordering the FBI to do mass rape. That's an official.
No, I don't
What's
think that's
unofficial
true.
about that?
Because just because it's being done to the order is given to the FBI official doesn't mean that the order is part of the core function. I mean, to put it more plainly, if the president gave the order to the FBI official that I want you to go stump for me and and give political speeches for me,
Mm-hmm.
I don't think anyone would say that's part of the core function of the president.
Yeah.
People
Okay. Wait.
not giving
I
that
wait.
order to
So
the FBI.
yeah. I think I agree. I don't know if Pisco agrees or not. I agree. But under this ruling, how would you even make that determination? Who makes that determination if you're not allowed to review by virtue of the relationships, like anything that's even ordered there?
Well, they spend time talking about the delineation for this issue, and the issue versus the communication to the DOJ versus the communication to subordinates has a delineation here.
Sure, but I'm not talking about that. No, very, very clearly. And I'm not asking for you to say that they discuss it. I want to know, either you can tell me what they discuss or what they answer. How would you do it? I see that all over the state that I live in, FBI agents are running around raping black people. And then there's a leak that comes out, somebody recorded with their iPhone 15 Pro, the president talking to, his new attorney general, Sidney Powell or whatever. And he's saying like, make sure to, get this done or whatever. We want them all raped or whatever. And I go, hey, this is obviously criminal in nature. How do you even begin to probe that when the court says, I'm sorry, but the president of the United States, in executing the laws of this country and communicating with his attorney general, this is a core function of the president. He's literally speaking as president to ostensibly to enforce laws to his AG. How do you review it? Where do you get the test from here? Like, what do they say in this case? I haven't read far enough. Do they address that? Because it seems like the answer would always be, sorry, that's not reviewable, bro. This is literally the president's core job.
I think the verbiage in the case does try to delineate that, and
How?
it's not as clean.
Well, no, I'm asking how. You keep saying they do it. How do they do it? What is the delineation? How?
Let me pull up the opinion, and I'll get back to you on the language.
Okay.
Well, just to state my opinion, I'm just going to say it, like, it's horseshit. There is no delineation here. It's absolutely a core executive function to order your, or to have communications with the Department of Justice. That was the example they used of Trump, like, talking to his DOJ and starting these bogus investigations based on corruption. And if you want to say like, okay, mass rape, that's not clear or whatever, fine, I can change it up. I'm not going to let you dodge the hypothetical.
We can say mass arrests or whatever, right?
Well, going even further than that, you agree, I'm sure, because you won't deny it, that one of the FBI's jobs is to stop terrorism. And in the effort of stopping terrorism, you kill terrorists who are imminent threats. And so the president issues an order to an FBI field office or to its head, if you want to make that little principal inferior officer distinction, I don't care. The order is brought from the president, and he says, I want you to kill a terrorist. The terrorist is threatening the country. That terrorist is an imminent threat, and that terrorist's name is Nancy Pelosi. Unreviewable. Absolute immunity for that action. And don't tell me it's not a core function to order the FBI or to order the DOJ. And don't tell me that stopping terrorists isn't a core function of the FBI.
Okay, I won't tell you that.
Well, hold on, wait, real quick. Also, just somebody in chat says,
how do you support it?
what's Pisco's rebuttal to yes, there's no criminal recourse. There's political recourse through impeachment or the voting booth. These are criminal consequences for something are not the same as an electoral consequence. Nobody's talking about an electoral consequence. We're talking about whether or not somebody should be above all forms of criminal prosecution. I don't know why you keep bringing that up.
And if you want to keep having elections, chatter, one way to do that is to make sure that you don't make a rod for your back and have these court rulings that open the door to tyranny, to people who literally try to steal an election. Your country, your Department of Justice is trying to enforce the law as against someone who tried to steal an election. And the Supreme Court says it doesn't matter if you try to coup d'etat using the military, because if you try to coup d'etat using the military as commander-in-chief, that's a core executive function. And as long as he made the order to his junta, that's unreviewable. You can't use it as evidence. And the act, you have absolute immunity for it. What is this bullshit? What is this equivocation that I don't know if I like, I don't know if I read it? You don't even need to read 100% of it. I've read it, but you don't even need to read it to know it's un-American. This is bullshit. And you shouldn't stand for it and hear these kind of like, I don't know, oh, it's not as bad as people say, it's whatever. No, this is bullshit. It's un-American. And anyone trying to gaslight you and say it's not is lying to you.
Do you think they're lying, or do you think maybe they just disagree with you?
They're lying to you that this is not a significant grant of authority and immunity. I mean, it gave Trump everything he wanted and more. It effectively, it's limitless and potentially in its scope. Think about like what really would be an unofficial act for a president. If you like driving a car around, you can say I'm driving because I'm going to go meet some voters, because I'm going to, this is part of me doing my bully pulpit. I mean, I struggle to think of any action one could take that he couldn't trivially turn into an official act. It is gross that anyone could be defending this on any ground. I mean, and to think also like that's just kind of like what it feels like, but now put inside the analytical components, the analytical pieces where look at this hypocrisy. For years we've been talking about textualism. Where's the textualism? There's no immunity text. Where's the history, right? All of a sudden, right? We don't have a storied history of absolute.
Well, the history are a couple court cases against Donald Trump, apparently.
And the court says, what would we do if these presidents are chilled from all this criminal? Guess what? This presumption has never existed until now. This is the first time anyone
Which
has
I think
ever
is the
raised
problem. They're trying to be forward-looking about this a little bit because they're worried about what does happen in the future, which the Supreme
Yeah,
Court.
but here's
fine.
this is a consideration that I hope is addressed in here. But they keep talking about the idea that like, well, if this consideration is a new thing going forward, it might have a chilling effect. Well, do you think there might have always been this consideration? Like here, this would be a question I have. Again, I have only read up to 19 pages of this, but like, if Nixon would have gone into the future and read this decision, would he have even bothered resigning? Like what? Like why? If he felt like he could fight in court, like is it not possible that this chilling effect has not only already existed, but maybe it's a good chilling effect that some people don't think that they're above all forms of criminal prosecution? Like maybe that's a good thing, and maybe people have already been acting like it. Like this is something that I would want to see for a historical analysis. I would want to see conversations, and I've already seen some by Jack Smith because he put it before the federal court for his indictments, that it feels like when you read, especially about Nixon, I mean, it's our most related example, that there was an assumption that presidents could indeed be criminally prosecuted, and that was something that they were operating under. I would be curious to see if under Nixon, if there were arguments at the time of people saying, oh, no, Nixon will probably be fine. Don't even bother pardoning him. Like, we already know that presidents have unlimited immunity when they're doing things that are even on the outer perimeter of their actions. Like, he'll be fine. Like, just fuck it. Did that discussion ever happen? Yeah, go ahead.
I think the outer perimeter is at least partially an answer to some of Pisco's concerns, because I seriously doubt that you can make a credible argument that the FBI ordering, the mass sexual assault of people is within the outer perimeter of his official responsibility.
Sure. Wait. We don't even have to use a hypothetical here. What about Donald Trump going to Mike Pence and saying, "Hey, I don't want you to count these 7 electoral slates. I want you to count the illegitimate ones that I did instead." That's absolutely a core power to discuss.
No, they disagree with you. They thought that it was more ambiguous than that. The decision.
Wait, are you sure? I thought that they explicitly called that out and said that this was a core power for.
They said the DOJ one was, but they said the Pence thing was more ambiguous.
It's about like whether or not that it's a close call, that like he could be exercising his legislative function as the president of the Senate, and so perhaps those communications. I mean, like, what are we talking about here, right? Look at the formalism that the court is willing to go through. To try to like.
Just as a real quick thing, conversations between Trump and Pence about their official duties, that is presumptively immune from prosecution for such conduct. So the government has a burden to even prove that they have to rebut the presumptive immunity to even begin to probe that for the conversation between Pence and Trump. And that was even given the indictment was true, given all the facts were true. That was in the initial outset, whenever the president was, so.
Yeah, they want the lower courts to analyze it in a more detailed way. So they weren't able to say as a categorical matter. They wanted a more nuanced consideration of the degree to which it was official versus unofficial acts.
Yeah. Sure, but if the court's been like generous in how it sees things to the president, like how generous are they going to be for what counts as an official act? Like if you were willing to rule this generously right now on all this immunity, like I feel like, because if their argument is, well, it can't be something that's going to unduly burden the executive. I mean, if the president or an ex-president is saying this would unduly burden me, and if that's the argument they're making, I mean, like, Jesus, it seems like what wouldn't burden an executive here? I don't know what the threshold is, but maybe they give a good test for it, and I'll see it later on in this ruling, maybe.
And you can come with a thousand examples that go to core executive function. that, I mean, I want answers from like about one of them on civil law. I'm sorry to be a dick. I just think I love this country, and I think that this ruling.
I love this country too, whether you believe that or not.
Well, then I feel really upset that you would be like somewhat okay with this. I think anyone who loves this country needs to recognize what an aberration this is. And we can run through a trillion hypotheticals, where, I don't know, you ordered the DHS to deport a U.S. citizen on purpose to Mexico. Or that's core. You're ordering an agency. You're ordering them to do something in their power to deport. You're doing it on purpose. You're deporting a U.S. citizen on purpose to like throw him out of the country to like, I don't know, to drug land. How can this be that the president can so easily be above the law? Even if you say, oh, there's technically maybe some areas where he might not be, it's trivially easy for him to be above the law. That should tell you something, that just by corrupting his own administration, that's the best way to get away from criminal liability. That's the incentive structure.
It may be me mishearing it, but I understand that as more of an emotional appeal by looking to the potential horribleness of the consequences rather than a straight legal analysis. Because if you assume the premise that the correct legal answer is this, then that's just the correct legal conclusion.
Well, hold on, wait. I would say
horrible conclusions, but that's the correct answer.
Well, I would say wait, real quick, to be careful. It's not just a strict legal thing. Like, part of the legal consideration, or you can say it's a strict legal thing, but part of the legal consideration is this going to be an undue burden on the executive? That's part of the consideration.
Yes. So absolutely true. What Stephen told you, and what's clear from the opinion, is that more than anything, the court is citing like what it thinks are going to be the consequences and what's going to burden the executive or not burden the executive. And so I think if you're doing that, consequences are fair game, and like you can go over that. But I don't even need to go there, because as with all like legal things, we start with the text. Okay. Is there any immunity clause in the Constitution? No. There is no immunity clause in the Constitution. Okay. Now let's go look at the history, founding documents, legislative history. Is there any Federalist paper, communications at the time of the founding, discussions about what absolute immunity is, discussions about core executive versus no, there's nothing. Absolutely zero. Is there any like historical practice where there's a letter where Abraham Lincoln says, I am criminally absolutely immune, where they use these terms, or any kind of practice whatsoever? No, there's none. And so when you start talking to me like, what's the legal analysis? What's the legal analysis for assuming that a provision that doesn't appear is real? I can grant you that there could be certain congressional statutes that are incompatible for like with the Article 2 of the Constitution. Like, I would agree that like if Congress purported to criminalize the president's ability to make a pardon, I would be like, yeah, it's unconstitutional under normal separation of powers principles, not under immunity. You don't have to invent an immunity doctrine for that. You just say this law as applied, violates the Constitution. Why you have to invent this immunity structure? It's totally made out of thin air. It's bullshit.
What's the practical difference between saying there's immunity versus the laws unconstitutional?
A lot of practical differences. So number one is you don't have this like ridiculous evidentiary thing where, we can't consider your intention and motivation. That's Looney Tunes. Of course we consider people's motivations when we're determining something's official or not official. If I talk to my DOJ like about getting into my pool, that's a conversation with the Department of Justice. But like my state of mind, what I'm like, the nature of what I'm saying, right? Like you have to consider people's intentions, whether things are sham, to understand if it's official, right? Otherwise, anyone could just put something in a memo and all of a sudden it's official. If you're not really interrogated and taking a second look at the shamness of it. And so because absolute immunity doctrines are by their nature, they don't want to do that, because by doing that, now it's just ground down into like the actual crime itself. And so the whole immunity is obviated if you need to have a trial about your intent level, and then just like the sphere of immunity overlaps with the underlying criminal conduct. And so this gets rid of that bullshit, number one. And then number two, practically, we can have trials and we can discuss whether it's unconstitutional after the application of those, like we do for every other criminal defendant in this country. Every other, and that's equality under the law, right? If there's something that's unconstitutional under state law, you try at the trial level, and if it doesn't work, you appeal after the trial. That's almost always how it works. But
but if we take the pardon as an example, suppose Congress just passes a law that says it shall be illegal for the president to pardon a non-citizen, and the president pardons a non-citizen, and we put him on trial. Are you trying to say that there shouldn't be some sort of motion to dismiss?
Yeah, there should be. There should be a motion to dismiss. There should be a motion to dismiss on the front end. It should be granted. But if it's not, and again, different jurisdictions might differ on their rules for interlocutory appeals, I suppose. But at the very minimum,
this is federal, so hopefully it's uniform.
Hopefully it's uniform. And I think there'll be. I don't actually know the interlocutory rules for appeals. It's somewhere. You guys can look it up. But whatever it is, there is a practical difference to an immunity doctrine versus just ruling things are unconstitutional. And the proof is in the pudding here. They went with immunity, and you see the consequences of it. And you see my world is completely different. In my world, we're not having this conversation of these ridiculous hypotheticals, which I'll note you haven't been able to address, right? You haven't been able to address the ordering of the FBI to kill a pro forma on paper terrorist named Nancy Pelosi. There's nothing that you're going to be able to provide about that situation that distinguishes it from.
Okay, on civil law, I get a response, and then I get the. And I'm going back to
17, which kind of tries to deal with this. I don't know that you will find it satisfactory, but they try to address this delineation about official versus unofficial responsibilities. And they talk about, for example, at the bottom of this is PDF page 25, marked page 17. At the bottom of the page, they talked about immunity extends to the outer perimeter. They're not manifestly or palpably beyond the authority. I was thinking you're hypothetical that you could make a pretty credible argument that would not be within his authority.
Okay. The last thing I'll say,
go quick.
I'll submit that whatever manifestly not within the authority is true here, as it is in that hypothetical, and that's all I'll say.
Okay, love you. All right, jeez. In Nixon v. Fitzgerald, for instance, we recognize that as a functionally mandated incident of his unique office, a former president is entitled to absolute immunity from damages, liability predicated on his official acts. That case involved a terminated Air Force employee who sued former President Richard Nixon for damages, alleging that Nixon approved an Air Force reorganization that wrongfully led to his firing. In holding that Nixon was immune from that suit, our dominant concern was to avoid diversion of the president's attention during the decision-making process caused by needless worry as to the possibility of damages actions stemming from any particular official decision. The singular importance of the president's duties implicating matters likely to arouse the most intense feelings, coupled with the sheer prominence of his office, heightens the prospect of private damages suits that would threaten such diversion. We therefore concluded that the president must be absolutely immune from damages liability for acts within the outer perimeter of his official responsibility. By contrast, so this makes sense that you would want a president to be immune from civil litigation. You don't want somebody suing the president because they feel like he did a thing that cost them their job or something, right? We wouldn't want that. That makes sense. I think I would agree that makes sense. By contrast, when prosecutors have sought evidence from the president, we have consistently rejected presidential claims of absolute immunity. For instance, during the treason trial of former Vice President Aaron Burr, Chief Justice Marshall rejected President Thomas Jefferson's claim that the president could not be subjected to a subpoena. Marshall reasoned that the law does not discriminate between the president and a private citizen, United States v. Burr. Because a president does not stand exempt from the general provisions of the Constitution, including the Sixth Amendment's guarantee that those accused shall have compulsory process for obtaining witnesses for their defense, a subpoena could issue. Marshall acknowledged, however, the existence of a privilege to withhold certain official papers that ought not, on light ground, to be forced into public view. This says even ought not on light ground, implying that there would be some grounds to do it potentially, but Destiny, ban soccer talk, please. We don't need these. If there are people talking soccer, tell me. I'll 90-day ban them. Where are they? Who? Give me a soccer word.
Again?
What?
What are you looking for?
Oh, these fucking retards in my chat talking about some fucking poverty ball game.
Oh.
Okay. I'll keep an eye out for it. And he noted that a court may not be required to proceed against the president as against an ordinary individual. United States v. Burr. This might be a case we want to look up a little bit. United States v. Burr about compelling a president to turn over evidence for a subpoena.
I
Similarly,
know your chat won't be disappointed, but I only have about a half hour before I have to leave in case you want to discuss anything more. But if not, that's cool.
okay, I'm just reading through. I have questions
Fair
I'll
enough.
answer, but otherwise I'm just reading, yeah.
Press on.
Similarly, when a subpoena issued to President Nixon to produce certain tape recordings and documents relating to his conversations with aides and advisors, this court rejected his claim of absolute privilege given the constitutional duty of the judicial branch to do justice in criminal prosecutions. This is in U.S. v. Nixon, 418. Okay, so I still have this case. But we simultaneously recognized the public interest in candid, objective, and even blunt or harsh opinions in presidential decision-making, as well as the need to protect communications between high government officials and those who advise and assist them in the performance of their manifold duties. Because the president's need for complete candor and objectivity from advisors calls for great deference from the courts, we held that a presumptive privilege protects presidential communications. That privilege, we explained, relates to the effective discharge of a president's powers. We thus deemed it fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. Criminally prosecuting a president for official conduct undoubtedly poses a far greater threat of intrusion on the authority and functions of the executive branch than simply seeking evidence in his possession, as in Burr and Nixon. The danger is akin to, indeed greater than, what led us to recognize absolute presidential immunity from civil damages liability, that the president would be chilled from taking the bold and unhesitating action required of an independent executive. I would have to read these other court cases, and I might go over at least the executive summaries of them, but I still wholly disagree with that assessment. The idea that there is as much of a threat for criminal prosecution as there might be for like a subpoena just doesn't seem on its face. I feel like that argument needs further justification, because I could see way more subpoenas happening than criminal indictments. That seems to be a more exceptional circumstance. But although the president might be exposed to fewer... Oh, they're going to say it right here. Okay. Although the president might be exposed to fewer criminal prosecutions than the range of civil damages suits that might be brought by various plaintiffs, the threat of trial, judgment, and imprisonment is a far greater deterrent. Potential criminal liability and the peculiar public opprobrium that attaches to criminal proceedings are plainly more likely to distort presidential decision-making than the potential payment of civil damages. Yeah, again, I don't think I agree. Yeah, I don't know. The hesitation to execute the duties of his office fearlessly and fairly that might result when a president is making decisions under a pall of potential prosecution, McDonnell v. United States, raises unique risks to the effective functioning of government. A president inclined to take one course of action based on the public interest may instead opt for another, apprehensive that criminal penalties may befall him upon his departure from office. I hope they give an example. I really want them to give a hypothetical decision here. I hope they do. And if a former president's official acts are routinely subjected to scrutiny in criminal prosecutions, the independence of the executive branch may be significantly undermined. The framers' design of the presidency did not envision such counterproductive burdens on the vigor and energy of the executive. Federalist number 70 at 471. We must, however, recognize the countervailing interests at stake. Okay, so here hopefully we get on the criminal side of things. Federal criminal laws seek to redress a wrong to the public as a whole, not just a wrong to the individual. There is therefore a compelling public interest in fair and effective law enforcement. The president, charged with enforcing federal criminal laws, is not above them. Chief Justice Marshall's decisions in Burr and our decision in Nixon recognized the distinct interests present in criminal prosecutions. Although Burr acknowledged that the president's official papers may be privileged and publicly unavailable, it did not grant him an absolute exemption from responding to subpoenas. Nixon likewise recognized a strong protection for the president's confidential communications, a presumptive privilege, but it did not entirely exempt him from providing evidence in criminal proceedings. Taking into account these competing considerations, we conclude that the separation of powers principles explicated in our precedent necessitates at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibility. Such an immunity is required to safeguard the independence and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution. Okay. Okay, I guess we just assume it then. Okay. Indeed, if presumptive protection for the president is necessary to enable the effective discharge of his powers when a prosecutor merely seeks evidence of his official papers and communications, it is certainly necessary when the president seeks to charge, try, and imprison, when the prosecutor seeks to charge, try, and imprison the president himself for his official actions. At a minimum, the president must therefore be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. I think I broadly...
So that's where I sort of had a problem, because this is talking about that space in between the core acts and the unofficial acts, just the official acts. And they say he's immune unless you can show this. And as far as I can tell, there's no other analysis anywhere in the opinion that explains what this is. So if I'm a district court, I have no idea how to apply this, which is very frustrating.
Yeah, that seems kind of weird, but I'll keep reading. I'll see if they try to address that, but...
I don't know what that means. No danger to the intrusion. What does that mean? How am I supposed to decide that? What factors should I use? The Supreme Court gives me nothing.
Sure. Ugh. Okay. But as we explained below, the current stage of the proceedings in this case does not require us to decide whether this immunity is presumptive or absolute. Because we need not decide that question today, we do not decide it. One case in more than 2 centuries does not afford enough experience to definitively and comprehensively determine the president's scope of immunity from criminal prosecution. As for a president's unofficial acts, there is no immunity. The principles we set out in Clinton v. Jones confirm as much. When Paula Jones brought a civil lawsuit against then-President Bill Clinton for acts he allegedly committed prior to his presidency, we rejected his argument that he enjoyed temporary immunity from the lawsuit while serving as president. Although presidential immunity is required for official actions to ensure that the president's decision-making is not distorted by the threat of future litigation stemming from those actions, that concern does not support immunity for unofficial conduct. The justifying purposes of the immunity we recognized in Fitzgerald and the one we recognize today are not that the president must be immune because he is the president. Rather, they are to ensure that the president can undertake his constitutionally designated functions effectively, free from undue pressures or distortions. It is the nature of the function performed, not the identity of the actor who performs it, that informs our immunity analysis. But I wonder how you figure out the nature of the function performed. But nature, not the nature, but maybe the nature just means doing it. But I don't know. We'll see. The separation of powers does not bar a prosecution predicated on the president's unofficial acts. 2 or 3, chapter 3. I don't know what you would call this, section 3. Determining whether a former president is entitled to immunity from a particular prosecution requires applying the principles we have laid out to his conduct at issue. The first step is to distinguish his official from unofficial actions. In this case, however, no court has thus far considered how to draw that distinction in general or with respect to the conduct alleged in particular. Despite the unprecedented nature of this case and the very significant constitutional questions that it raises, the lower courts rendered their decisions on a highly expedited basis. Because those courts categorically rejected any form of presidential immunity, they did not analyze the conduct alleged in the indictment to decide which of it should be categorized as official and which unofficial. Neither party has briefed that issue before us, although they discussed it at oral argument in response to questions, and like the underlying immunity question, that categorization raises multiple unprecedented and momentous questions about the powers of the president and the limits of his authority under the Constitution. As we have noted, there is little pertinent precedent on those subjects to guide our review of this case, a case that we too are deciding on an expedited basis, less than 5 months after we granted the government's request to construe Trump's emergency application for a stay as a petition of certiorari, grant that petition, and answer the consequential immunity question. Given all these circumstances, it is particularly incumbent upon us to be mindful of our frequent admonition that ours is a court of final review and not first view. Critical threshold issues in this case are how to differentiate between a president's official and unofficial actions, and how to do so with respect to the indictment's extensive and detailed allegations covering a broad range of conduct. We offer guidance on those issues below. Certain allegations, such as those involving Trump's discussions with the acting attorney general, are readily categorized in light of the nature of the president's official relationship to the office held by that individual. Other allegations, such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public, present more difficult questions. Although we identify several considerations pertinent to classifying those allegations and determining whether they are subject to immunity, that analysis ultimately is best left to the lower courts to perform in the first instance. A. Distinguishing the president's official actions from his unofficial ones can be difficult. When the president acts pursuant to constitutional and statutory authority, he takes official action to perform the functions of his office. Determining whether an action is covered by immunity thus begins with assessing the president's authority to take that action. But the breadth of the president's discretionary responsibilities under the Constitution and laws of the United States in a broad variety of areas, many of them highly sensitive, frequently makes it difficult to determine which of his innumerable functions encompassed a particular action. In some presidential conduct, for example, speaking to and on behalf of the American people, certainly can qualify as official even when they are not obviously connected to a particular constitutional or statutory provision. For those reasons, the immunity we have recognized extends to the outer perimeter of the president's official responsibilities.
Yeah, and this was the page that I was trying to highlight earlier as trying to answer some of your and Pisca's questions. This page 17, which is trying to delineate when you can say it's official versus non-official.
Mm-hmm.
So that's a partial answer to your question, I hope.
Gotcha. Hold on.
So, as they say, they're looking for the president's authority within the respective thing that he's trying to do. So, for example, I think some of the examples you gave, or Pisco gave, rather, with respect to the FBI, I think you'd have a difficult time, even though their orders to the FBI saying that they're within the authority or perimeter of his official responsibilities. I think that would be a tough sell.
Sure. Okay. Let's see. To our question was submitted, noting that we have refused to draw functional lines finer than history and the reason. Okay. Boom. Let me hold on. In dividing official from unofficial conduct, courts may not inquire into the president's motives. Such an inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose, thereby intruding on the Article 2 interests that immunity seeks to protect. Indeed, it would seriously cripple the proper and effective administration of public affairs as entrusted to the executive branch of the government if, in exercising the functions of his office, the president was under an apprehension the motives that control his official conduct may at any time become the subject of inquiry. We thus rejected such inquiries in Fitzgerald. I just want to read this real quick. I need to see inquiries in Fitzgerald. Okay, Fitzgerald, 457 U.S. at 745. Nixon v. Fitzgerald. When it says at 745, does that mean page 745 or?
Yeah.
Damn, that's a long ass fucking thing.
Well, that's 745 in the volume, not 745 of the opinion.
Or wait, it's 457 US means.
Yeah, 457 is the volume. 745 is the page number.
Yeah. So 740. That's a lot of pages.
In the volume, yes, but there are a lot of things in the volume. Just one opinion.
So the volume it's volume 457. It's page 745 in the volume, but the whole pages isn't all the opinion. I understand. Okay.
Right. Yeah.
Okay. Primary holding. Oh wait. Okay. This is the entire.
Yeah, 731 is the starting of the page number, and then 745 is the pinpoint.
Okay, I just want to read part of this section because it keeps getting referenced here. This court consistently has recognized that government officials are entitled to some form of immunity from suits or for civil damages. And Spalding v. Okay, so this is the Nixon v. Fitzgerald case from 1982 that I'm reading from now. The court considered the immunity available to the Postmaster General in a suit for damages based upon his official acts, drawing upon the principles of immunity developed in English cases at common law. The court concluded that the interests of the people required a grant of absolute immunity to public officers. In the absence of immunity, the court reasoned executive officials would hesitate to exercise their discretion in a way injuriously affecting the claims of particular individuals, even when the public interest required bold and unhesitating action. Considerations of public policy and convenience, therefore, compelled a judicial recognition of immunity from suits arising from official acts. So this is still talking about civil stuff right now, but in exercising the functions of his office, the head of an executive department, keeping within the limits of his authority, should not be under an apprehension that the motives that control his official conduct may at any time become the subject of inquiry in a civil suit for damages. It would seriously cripple the proper and effective administration of public affairs as entrusted to the executive branch of the government if he were subjected to any such restraint. Decisions subsequent to Spalding have extended the defense of immunity to actions besides those at common law. The court considered whether the passage of 42 U.S.C. 1983, which made no express provision for immunity for any official, had abrogated the privilege credible comments would impinge on a tradition so often. Recognize. We rejected the official's claim of absolute immunity under the adultery on various. Portion of the nature of the official functions and the range of decisions conceivable might take in good faith. This functional approach also defined a second tier, however, which the especially sensitive to certain official not only require absolute immunity. State prosecutors possess absolute immunity with respect to the initiation and pursuit of prosecutions. Detailed by budget. Okay. Okay. I wonder if there's any talk of any criminal. 457, okay, with the President of the United States v. Nixon. Wait. But our cases also have established that a court, before exercising jurisdiction, must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. See Nixon v. Administration and United States v. Nixon. When judicial action is needed to serve broad public interests, as when the court acts not in derogation of the separation of powers, but to maintain that proper balance, or to vindicate the public interest in an ongoing criminal prosecutions, the United States of America, the exercise of jurisdiction has been held warranted. In the case of this merely private suit for damages based on presidential acts, we hold it is not. When judicial action is needed to serve broad public interests, as when the court acts not in derogation of the separation of powers, but to maintain their proper balance, and then they cite Youngstown, Sheet, and Tuco v. Sawyer, or to vindicate the public interest in an ongoing criminal prosecution, see United States v. Nixon, the exercise of jurisdiction has been held warranted. In the case of this merely private suit for damages based on a president's official act, we hold it as not. So it sounds like in this case, in Nixon v. Fitzgerald, the court is saying that when we're trying to maintain certain balances of power and when we're vindicating public interest, such as in an ongoing criminal prosecution, we say that the jurisdiction exercised by the courts here is warranted. Okay, interesting. So that seems to be a bit contrary to what the court is ruling here. I think that's fair to say, maybe, but I'm curious. If I had time, I would read this whole thing, but I don't have time to read every single fucking court case. It's just the Supreme Court keeps hearkening back to this Nixon v. Fitzgerald case, but what I'm curious about, what I'm thinking about right now is, do they only reference it when it's talking about limiting prosecution, but they're explicitly referring to civil matters? I'm curious if this Nixon v. Fitzgerald case references criminal matters and what the court thought then. So that's why I'm looking for criminal stuff.
I don't think there is much criminal stuff as part of the point. So
well, hold on, wait. To be clear, what I just read,
civil.
That seemed to recognize that some ongoing criminal prosecution to vindicate public interest was warranted. So it seems like it does reference it, but whenever it references criminal stuff, at least in this first quote that I found, it seems like it's referencing it to uphold that criminal prosecution in the public interest might be necessary. That's at least that in that one thing I'm just going through for references of criminal right now is what I'm looking at.
This is with respect to evidentiary privilege. So in this case, I believe they were getting only evidence with respect to a independent prosecution.
Sure.
Rather than, so it's if you like, almost like a civil process because it's obtaining the evidence related to a criminal case.
Sure.
It's not quite right, but hopefully it gets the idea across.
Seeing any other criminal references? The court has recognized before that there is a lesser public interest in actions for civil damages than, for example, in criminal prosecutions. Based holding on special importance of evidence in a criminal trial distinguishing civil actions as raising different questions not presented for decision. It never has been denied that absolute immunity may impose a regrettable cost on individuals whose rights have been violated, but contrary to the suggestion of Justice White's dissent, it is not true that our jurisprudence ordinarily supplies a remedy in civil damages for every legal wrong. The dissent's objections on this ground would weigh equally against absolute immunity for any official, yet the dissent makes no attack on the absolute immunity recognized for judges and prosecutors. This is, are we reading? Can I assume this is still, they're referencing the dissenting opinion, so this must be the majority opinion. I'm assuming that's, if they're referencing it, right? Law, which there is not damages, remedy for every legal wrong. These cases establish that victims of statutory crimes ordinarily may not sue in federal courts in the absence of express congressional intent. Okay, nothing much here. You will notice in the majority's opinion that they make no mention of this public interest in pursuing violations of criminal law. Dissent makes that point later. Yeah, maybe. Yeah, that's yeah, because I see that public interest is comes up quite a bit. And now, even though criminal prosecutions are of a greater thing, arguably a greater category of things than civil prosecutions, the public interest is much greater as well, right? There is a large public interest in enforcing criminal laws and criminal prosecutions and the conviction of criminals, as opposed to, you know, whatever civil bullshit, right? But. Mm-hmm. Let's see, what else? Any other? In his dissenting opinion, Justice White's judicial process, civil damage suit, he quotes the language. First, it is important to remember that the context of that language is a criminal prosecution. Second, the judicial process referred to was sitting at a subpoena to the president to produce relevant evidence in a criminal prosecution. No issue of damages immunity was involved either in Burr or the United States v. Nixon. In short, the quoted language has no bearing whatever on a civil action for damages. It is one thing to say the president must produce evidence relevant to a criminal case, as in Burr and United States v. Nixon, and quite another to say a president can be held for civil damages for dismissing a federal employee. If the dismissal is wrongful, the employee can be reinstated with back pay, as was done here. The immunity of a president from civil suits is not simply a doctrine derived from this court's interpretation of common law or public policy. Absolute immunity for a president for acts within the official duties of the chief executive is either to be found in the constitutional separation of powers or it does not exist. The court today holds that the Constitution mandates such immunity, and I agree. The essential purpose of the separation of powers is to allow for independent functioning of each co-equal branch. I think still speaking in terms of civil damages liability here, but court intimates that its decision is grounded in the Constitution. If that such case, Congress cannot provide a remedy against presidential misconduct. The criminal laws are wholly inapplicable. Okay. This is still, I just want to make sure I'm still reading the majority opinion. Fuck. Is there an easy way to tell whose opinion I'm reading without having to scroll all the way to the...
Not really, no.
How fucking annoying.
Yeah, there you see where it says white. You're reading the dissent.
Okay.
Yeah, see, it says when it says it, the big bold letters.
Justice White, with whom Justice Brennan, Justice Marshall, and Justice Blackmun join, dissenting. So this is the dissenting opinion now. The court intimates that its decision is grounded in the Constitution. If that is the case, Congress cannot provide a remedy against presidential misconduct, and the criminal laws of the United States are wholly inapplicable to the president. I find this approach completely unacceptable. I do not agree that if the office of the president is to operate effectively, the holder of that office must be permitted, without fear of liability and regardless of the function he is performing, deliberately to inflict injury on others by conduct that he knows violates the law. The court intimates that its decision is grounded in the Constitution. If that is the case, Congress cannot provide a remedy against presidential misconduct, and the criminal laws of the United States are so in the dissent here, it sounds like they're worried about this decision because they're saying, well, if this is the decision, then you're basically saying that the president, they're basically saying that this decision that happened today would happen, is the worry that's being expressed by the dissent here. This was a 5-4 decision. There weren't like 20.
Fitzgerald? Yeah, probably.
Okay.
I got to run for the moment,
Yeah,
but I
good.
hope you have a good stream, my friend.
All right, have fun.
Bye-bye.